Court officer? GMFC, my lord. Day after tomorrow, my lord. Stay has been granted by this honorable court. Day after tomorrow, kindly.
My lord, I am Dharwad bench, my lord. My lord, make submission. My lord, may I make submission, my lord?
MFA matter, my lord. For admission.
This Dharwad matter.
May I make submission, my lord?
Yes.
That's RPI I was moved, my lord. That was listed on today, but it was not listed. It is contempt has been filed. It is listed on tomorrow, my lord.
All right. Have it tomorrow.
Tomorrow, please, my lords, to intimate. So my colleague is there, my lords. He has also moved.
The number.
Page wise, list number 1. Page number 9, seal number 42 to 49.
43, my lord. 43. 2 weeks not there. This is with regard to damage to the.
Request. Learned counsel for the corporation call after 2 weeks.
Page 10, seal number 50 to 58.
Lordship, serial number 57. I'm for the respondent. I have informed the petitioner a week's time may be granted.
Yes.
With yes.
You are the respondent.
Yes, my lordship. I've informed the petitioner's
Request
advocate.
of respondent call this matter next week. He submits, he has informed the petitioner counsel.
Yes.
Serial number 60, my lords. Behalf of Kailash Shankar, I am representing, my lords. We have informed respondent advocate, my lords. Matter may be next week, any date, my lord.
Appellant counsel seeks time. Call next week.
Serial number 61, I am for respondent, my lord. Matter may be referred to Lok Adalat, my lord.
At request of both parties, matters referred to Lok Adalat.
Please, my lord. Much of that.
Page 12, 63. List number 3.
List number 3, field number 3.
Total 25.
List number 3, field number 3, my lord. Translation I have to file entire Kannada, even including judgment, maybe 6 weeks may be granted.
There is no what?
Because about 40 pages I have to get it translated.
Huh?
About 40 pages judgment, depositions, all police documents are in Kannada.
Are in Kannada?
Yes, my lord.
Unit PQ.
At the 25 the total.
Total 25.
How? This 3.
This 3 is total 25. All right. Learned counsel for the appellant seeks time. Produce these translated copies. 4 weeks.
6 weeks may be granted.
6 weeks time is granted.
Serial number 39, my lord. Translated copies has to be filed, my lord. 4 weeks, my lord.
This number
3, my lord.
same 30,
39, my lord.
39. How much time you want?
4 weeks, my lord.
4
All in Kannada, the deposition and everything.
6 time granted at request of appellant.
5, my lord. 4 weeks time will be granted, my lord. Translation I have to file of all the documents, my lord, including deposition. 4 weeks time will be granted, my lord.
5.
So by 5, my lord.
Serial number 5, 4 weeks time granted.
Much of it.
21.
Serial number 1, my
11.
lord. Translated copy, my lord. 5 weeks, my lord.
Madam, just call it why list wise. Why they all confused? List wise correct. Just list number 2. Anything is there? Huh? Page wise correct.
List 3. Page number 1. The serial number 1.
Hmm.
Translated copy, my lord. Paper for 5 weeks, my lord. 1.2 ಮತ್ತೆ 1.3 ಅಲ್ಲಿ ನಾನು appellant ಗೆ ಇದೀನಿ sir.
ಯಾವ್ದ್ರಲ್ಲಮ್ಮ?
Serial number 1. Serial number 1, list number 3.
Which number? All right. How much time you need?
5 weeks, my lord.
5 weeks time granted to produce furnished and translated copies at request of appellant.
Page 2, list 3. Any submission? Page 3,
Serial number 13, my lord.
page 4, serial number 7 to 9. Page 5, 10 and 11.
11 minute, 11 minute. 2 weeks make a time to
11, 2 weeks
Yes.
time granted at request of appellant.
grateful.
Page 6, 12 to 19.
13, my lord, it's a matter which is required to be remanded, my lord, like other matters, short date may be.
All this matter next week at request.
Serial number
Correct.
18. Serial number 18.
Huh?
Serial number 18.
18.
CP number 309 of 2024. This matter petition I am filing a wakalat on behalf of respondent today, madam.
What's your name?
Harish Enna.
Learned Counsel Harish N.R. undertakes to file wakalat on behalf of respondent registry to show his name all after 2 weeks. Next week.
22 election.
Hmm.
This number
Page 7, 20 to 26.
Lots of-
Suryanarayan.
22, Last another claimant has filed in appeal. MFA 8350 of 17.
All along with MFA
8350 of 17.
next week.
I think so.
21 my lord,
Look, serial number 14.
21 my lord. 21 may currently be taken next week.
ನಾವು ಯಾವ page ಅಲ್ಲಿ ಇದೀವಿ ಹೇಳಿ?
Serial number 14, the matter has been settled. Both the parties are present, my lord, so I report the settlement may be taken up today.
They are present today.
Please, I'll file the joint memo.
All right, we'll take it up.
Serial number 20, my lord.
21
Next week, my lord.
at request of appellant call next week.
Serial number 20, proxy counsel, my lord. The counsel is unwell, so for me to take time for about a week's time.
Proxy for whom?
Appellants, for appellants.
Appellant counsel seeks time. All next week.
Harvard Mentor. Page number 8, 27 to 30. Page 9, 31 to 35.
My lord, serial number 35, my lord.
Ah.
And for the respond counsel Uma Shankar. My lord, kindly next week, date may be given, my lord, old matter,
At request of learned counsel for the respondent.
next Tuesday,
Call on next Tuesday date. could-
please.
25th.
Much appreciated.
Page 10, 36 to 39. Page 11, 40 to 43.
See, serial number 43.
Hmm.
Whether I appear for respondent 6 to 8. Now, I do not know whether the matter would be taken up. This is 25th.
Final hearing, you'll have to go.
It
before
was a final hearing. It has to be heard finally.
the date coding. You have to take the date.
Serial number 40, my lord, we have taken the first week. Paper 40.
Serial number 43.
40.
List one nimsha irri, Mr. Counsel. Request of counsel for respondent 6 to 8. Call the list this matter on 9th. 9th, Mr. Jayaprakash.
Yes.
Really, Mr. Venkatesh.
40.
Ah.
9 forward. 9.
9th.
And
Serial
The request of counsel for the appellant list this matter on 9th.
Serial number 12, my lord, in the current list. The blood mix. After 2 weeks, my lord, there is a liabilities involved. They filed application for withdrawal of that amount. But paid recovery agಬೇಕಾದ್ರಲ್ಲಿ. In the last occasion, my lord, I have paid the amount, whatever the cost, my lord, condoning the delay, I have paid the amount to the Advocates Association and I have produced the acknowledgement also.
Hmm.
That is the reason, my lord, first week of, second week of April.
Who are you in this case?
My lord, I am the owner of the vehicle, N.K. Siddeshwara.
You're the appellant.
Yes, I am the appellant.
All right, it has to be heard on that IE for release and deposit.
Because liability is involved, that is the reason.
No order is passed on that release
Yes, please,
of the amount deposited by you.
please.
Go and argue the matter. We'll list it when Day after tomorrow. Day after tomorrow. Request of appellant list this matter day after.
My lord, serial number 62, my lords, list 1. It may be taken up after a week. Was late, my lord.
Which list?
62, my lord. List 1, my lord.
62. What do you want?
A week time, my lords.
You are for?
Respondent, my lord. It's a connected matter, my lord. 62 and 62.
You are claimant?
Yes, my lord.
Are you claimant?
Claimant, my lord.
Kolima. At request of the counsel for claimants. Is this matter next week?
Yes, my lord.
Yes, what about all other matters of Portal 25? We'll adjourn it. Any urgent matters? You can move the court, can be taken up. Any urgent relief of the matters of Lordship Justice Lalita? 25, Portal 25. None. All right. All matters are adjourned to second week of April. 7 to 9.
Serial number 14.
Huh?
Made a submission. This 3 serial number 14 may be taken up today, my lord.
Yes, list 3, serial number 14. Please take it. Give the file.
We'll file the joint memo now, my lords. Waiting for respondent counsel.
All right. 14 will be taken up.
Please.
And they are coming? They are here?
They are coming.
Other side advocate is here?
Other side advocate is coming, my lord. So that's why I'm waiting for them.
All right. You can mention as they come.
Please.
List 1 for being spoken to, serial number 1, Satisha T.
My lord, I am for the respondent, my lord. My lord, kindly see your lordship judgment at para 3.4, my lord. Para 3.4 at page 4.
There are 3
3.4.
Yes.
My lord, the trial court has awarded compensation of rupees 12,12,400. My lord, this amount to be changed to 15,28,800. Kindly take the trial court judgment, my lord. Trial court judgment, page 14, tabular form. Tabular form of the judgment. Page 14. The trial court has amended the judgment. Page 14. End of para 18. That judgment is corrected as 15,28,800.
Para 14 alla.
Page 14, my lord. Page 14.
Page 14 tabular column.
Yes, my lord. Total amount of compensation awarded by the tribunal. 15,28,800.
Then it is amended after that.
Allah, that is amended. Yes, correct. Yes. I'm mistaken vice versa.
Who has moved this memo for being?
I only, my lord.
Now you pay cost.
Sorry, man. Allah, ನನ್ನ ಹತ್ರ amended ಇದಿಲ್ಲ ಆಯ್ತು, judgment ಇಲ್ಲ ಆಯ್ತು. That is why.
Amended certificate copy.
ಇಲ್ಲ. Sorry.
It is later on amended by the trial tribunal to
12 and reduced to 12,12,000. Yes,
12,400.
Just now my referent sent the amended copy. ಈಗ ಕಳಿಸಿದಾರೆ ಅವರು. ಈಗ ನೋಡಿದ್ದೆ. Sorry. Sorry for the inconvenience.
ನೀವು ಅದನ್ನ ಕರೆಕ್ಷನ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀರಾ?
ಅಲ್ಲ, ಅದು ಅಮೆಂಡೆಡ್ ಕಾಪಿ ನನಗೆ ಮೊದಲು ಕೊಟ್ಟಿರಲ್ಲ, ಅವರು ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿತ್ತು. ಈಗ ಅವರು ಅಮೆಂಡೆಡ್ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟರು. So no correction is required, my lord. Sorry.
We're not counsel for the appellant has filed a memo for being spoken to.
No, my lord. Respondent, insurance company.
Myself.
Respondent has filed a
myself
memo for being spoken to. Same is dismissed as withdrawn.
Much obliged.
For orders, seal number 2.
Yes, notice to R2, madam.
Is the insured, your lordship. But since I have challenged both quantum and liability, I need to take 1 week's time. May kindly be given.
Time granted if needful done.
What is
notice
liability?
to R2.
Seal number 3. Pavan TG.
Same order.
Seal number 4. Vaidya Ravi Lakshmi Narayan.
The appellant, your lordship.
Same.
Number 5, Jagdish HT.
Same.
6, Gurudev Prasad KT.
One notice may be dispensed.
Yaudರಲ್ಲಿ 5 ಅಲ್ಲ?
5 years.
Notice to R1 dispensed.
To get already needful done.
Give notice to other respondents.
6, Gurudev Prasad KT.
Week's time.
Dispensation.
ಯಾರಿಗೆ?
R1.
Notice to R1 dispensed. Memo accepted. IE 1 of 23 allowed 290 days delay condoned. No interest for delayed period.
For admission. Till number 7,
R1 dispensed. IE memo accepted. 1 of 23 allowed 290 days condoned. No
8,
interest.
Gurudev Prasad.
ಇದರಲ್ಲೂ R1
ಇದರಲ್ಲಿ R1 ಅದರಲ್ಲಿ R1 ಗೆ steps ತಗೋಬೇಕು. This may be called along with 1385 of 23.
all along with MFA. Yes.
Till number 9, with CM.
Notice to R1 dispensed. Accepted.
Serial number 9.
Huh?
Serial number 9.1 and it's already served.
All right. In serial number 9, KJID who appears? State. I will borrow HCGP na AG. Huh? Learned HCGP is directed to take notice for respondents. 2 and 3, registry to show name in the cost list.
Till number 10,
IE 1 of 23 is allowed delay of 210 days condoned. You are for claimant.
Claimant.
The connected matter.
9.1.
CGP is directed to take notice for respondents 2 and 3. Registry to show name. IE 1 of 23 allowed 210 days. Is condoned, no interest for delayed period in both matters.
10,
Bring for that.
Venkatesh.
Weeks time may kindly granted to take steps to R1 second time, my lord.
Weeks time granted, needful done, notice to R1.
I have already deposited the amount as ordered by the court on 9/5/24, my lord, 3,31,000.
Appellant submits he has deposited the amount on 9/5/2020.
Please, ma'am, 3,31,854. Please.
Till number 11,
I prefer 2 weeks time for the first respondent. I have to take my correct address murder.
Weeks time granted.
2
needful-
weeks murder.
2 weeks.
I have deposited the amount as per the interim order.
Needful done, notice to R1. Appellant submits, he has deposited the amount as ordered by this court.
till number 12, Rupesh Abi.
The matter has been settled before the execution court, my lordship.
Huh?
Kindly 2 weeks time may be granted.
You know,
Matter has been settled before the execution court, my lord.
learned counsel for the appellant submits that the matter has been settled between the parties. He seeks 2 weeks accommodation, same is granted.
Please.
13, Shantraj K.
A week's time granted to do the needful.
14, Irimalaya.
Council test time,
Huh?
dispensation of R2 million.
Notice to R2 dispense memo accepted.
15,
Is for admission. Copy ಬಂದಿದೆಯಾ? ಬಂದಿಲ್ವಾ? Copy to be furnished.
Please.
till number 15, Karthik Natesh.
For the appellant, my lords. The day of 104 days may be condoned.
Process.
We'll do the needful, my lords.
A week's time,
There's also a connected appeal filed by the insurance company if they may be clubbed together.
all along with MFA.
MFA 7928 of 2024.
2024. 16, Renuka HR.
In 16, my lord, as far as complaints is concerned, on 16/1/2015, my lord, 25, sorry, on 16/1/2025, it has been deposited. I'll file a memo to that effect. Order has been
Right
completed.
service of notice of R2. Counsel for the appellant submits, she has deposited the amount on 16/5,
16/1/2025, my lord, before the trial court.
16/1/25
Yes.
before the tribunal. same is taken note of.
Number 17, Pradeep B.
It's week's time to comply office objection.
A week's time granted at request of appellant.
Number 18,
Lordship, there are two minor office objections. I may kindly be permitted to comply here since I have moved an application for stay, your
Counsel is
lordship.
permitted to rectify the objections during course of the day.
Yes, Your Lordship. And I have sought for a stay, your lordship, in this
What
case,
are those?
challenging the quantum.
In objections, in
Pardon, Your Lordship.
objections, what are the objections?
That is, the index has to, some columns of the index has been left blank, and also the pencil marks should be erased, your lordship. Which are in the judgment, you know.
Deposited statutory deposit. fund.
Yes, I have done it, your lordship.
You
Done it on
notice to the
10-3
respondent.
itself.
It's on time,
Pardon, your lordship.
on time,
Yes, your lordship, there is no delay in.
will be stay for operation execution of the impugned order. Award. Dated 6/1/25 in MVC 4832 of 23. Subject to the appellant depositing 50% of the award amount before the tribunal,
As your lordship, before this honorable court.
for
your
this
lordship.
court within 4 weeks from today. On such deposit, the amount shall be kept in FD in a nationalized bank.
Highly obliged.
number 19, Pratima SK. Dr. Malay.
Yes, madam.
This is regarding the jurisdiction issue.
Hmm.
I'm ready to. argue, my lords,
Want to
but
pass over?
I don't want to pass over, but they're not there. I understand. It's all right. Let it be passed over. I'm okay with that.
No, what is to be considered now?
Let's, the.
You are now not having the child with you.
One thing is not having the child. The second thing is the family court decides that Bangalore court does have jurisdiction, when all along the child has been residing in Pune, my lords, from past 12 years, from the time of birth, in fact.
You have to consider that.
All right, let,
Pass over.
all right.
Azhar
20, Hazar Ali Faruqi.
This is regarding the school issue.
or IB or that CG.
IB or, yes, my lords.
In fact, NEEV has even ICSC as a safety wall. If they say that IB is not sufficient, or it may creates a situation where the child is not able to cope up.
But I will pass orders after this hearing. Yes. Before admission, I will take up your matter.
Pass over.
After serial
Pass
number.
over, my lords.
Pass over. After 41, I will take up.
Before 1:30?
Yes.
All right. Great.
You want to attend anywhere, any other court?
No, that is the reason I asked. No, I'm all right, because 2:30 I have the matter, so
Before
that's
1:30, I
okay.
will take up.
Okay.
Hearing on IA, till number 21.
Kindly pass over. I'm appearing for the proposed respondent, my lord. Kindly pass over, my lord.
Proposed?
Respondents, my lord. We have filed the IA for improvement. Kindly pass over.
For the petitioner, madam. May pass over, madam.
Pass over.
Serial number 22. Veni Ravish Chandrasekhar.
DL ಇಲ್ಲ ಅಂತ ಹೇಳೋದು percentage taken by the higher side, please. 10% to be taken, 32% to be taken by the learner.
Main argument ಮಾಡ್ತಾ ಇದ್ದೀರಿ. Withdrawal of the amount ಇದೆ ಅಷ್ಟು ಹೇಳ್ಬೇಕು.
ಇಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಬೋದು ಅದು ರೆಡ್ಯೂಸ್ ಮಾಡಿ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಿ.
Why I should dispose your case in withdrawal of 2023?
ಅಲ್ಲ ಏನು ಪೇ ಅಂಡ್ ರಿಕವರಿ ಅಂತ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಆದ ಸರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ two judgments are there. Unless and until owner has to furnish the surety to the court for the amount deposited by us, then only amount to be released until judgment is. May I pass it over, please?
Who's appearing for the other side?
Prasanna K.
So you're challenging the liability.
Liability, DL ಇಲ್ಲ evidence ಮಾಡಿದ್ದೀವಿ. My lord, last hearing my lord submitted that there no pay and recovery only ಅಂತ ಹೇಳಿ. But pay and recovery ಮಾಡಿದ್ರು but owner has to furnish the surety before disposal of the amount to the claimants ಅಂತ ಇದೆ.
Owner has to furnish surety.
May pass it over, please. Pencil ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Move this monitor. I don't know how you put this monitor item.
But ಇದಾದ್ಮೇಲೆ ಯಾವ judgment ಬಂದಿದೆ I do not know.
Whether I can see him nor see her.
Para 13, please, my lord, middle of the, before release the amount, claimant.
Para? Which para?
The para 13, please, my lord.
Yes, before.
Before release of the amount to the claimants, owner of the offending vehicle shall furnish the surety to the, for the entire amount which the insurer will pay to the claimants. Asta, that is my submission.
So that you are safeguarded as a insurer.
My humble request, please.
But our idara illi.
Last time bandidri sir.
No, whether owner is here.
Owner sarvagidre.
So serve ಮಾಡ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ if he doesn't come? How this is going to be put into effect? Though there is a judgment of the Supreme.
ಸರ್ವಾಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಈಗ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಸರ್ವಾಗದ ಹೋದ್ರೆ judgment will pass against the insurance company.
Mr. Ravish.
Please, madam.
Now, what you're saying, I also agree with you.
Please.
In fact, I have already passed an order when the owner was present and he was seeking pay and recover.
Then only, please, madam.
I have said that when you're already present before the court, the question of insurance company paying and recovering from you will not arise because you're already present. In your case, now he is served.
Served and represented.
Unrepresented. He's not here.
Not here.
How this will come into effect? How you are going to enforce this? Asking him to pay when he is not even present, he will not come. Because that is what they take advantage of by this pay and recover. The owners will not come and for you to recover is next to impossible. What I understand, correct?
Please, definitely.
So you have to challenge before the Supreme Court once they made this judgment of pay and recover. How to recover? Again, you have to go to the executing court.
Executing court.
ಅದಕ್ಕೆ
ಅದರಲ್ಲಿ judgment ಇಲ್ಲ ಸರ್. ಇವನ್ ಅವ್ರು ಬರ್ದ ಹೋದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ has directed to execute the award, take the necessary steps against the owner ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ.
That you can take now also.
Please, madam.
Again, if you have to take now, you have to go and execute. How you will recover?
ಎಲ್ಲಿ ರಿಕವರಿ ಮಾಡಕ್ ಆಗುದನ್ನೇ ಇಲ್ರಿ ಅವ್ರು ಅಡ್ರೆಸ್ ನಾಗ ಇರೋದಿಲ್ಲ ತಪ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟಿರ್ತಾರ ಬಟ್ ಎಸ್ಕೇಪ್ ಫ್ರಮ್ ದಿ ಕ್ಲಚಸ್ ಆಫ್ ದಿ ಲಾ.
Correct, because we have made such precedents.
I don't have.
So court made precedent.
Supreme Court has not this much only, but there is no any.
What is the alternative? You have to come out with something intellectually. You have to advise and.
I requested all the my insurer to take up the matter to the Supreme Court.
Right.
You take a specific contention before the Supreme Court ಅಂತ ಹೇಳಿದ್ರಿ. ಕೆಲವು ತಗೊಂಡು ಹೋಗಿದ್ರಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಸರ್ ಇಲ್ಲಿ ತನಕ.
Was he absent even before the tribunal?
In this case, please, not.
ನಿಮ್ಮ ಕೇಸಲ್ಲಿ.
ನಮ್ಮ ಕೇಸಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಅಲ್ಲೂ ಎಕ್ಸ್ಪರ್ಟ್.
ಅಲ್ಲೂ ಎಕ್ಸ್ಪರ್ಟ್ ಇದೆ.
ಅಲ್ಲೂ ಎಕ್ಸ್ಪರ್ಟ್.
ಮೇಡಮ್ ನೀವಿದ್ದೀರಾ ಈ ಕೇಸಲ್ಲಿ? ಪ್ರಸನ್ನ. You are for claimant.
Please.
You have filed application for withdrawal.
Please.
I listed for hearing.
Tomorrow, day after tomorrow, like ಇದರಲ್ಲಿ ಏನಿಲ್ಲ ಸರ್, ಒಂದು 37% ತೊಗೊಂಡಾರೆ, 10% ತೊಗೊಂಡು ಮಾಡಿ ರೆಡ್ಯೂಸ್ ಮಾಡಿ ಉಳಿದಿದ್ದ ಪೇನ್ ರಿಕವರಿ ಮಾಡಿ ಸರ್.
All right. So you can argue the matter, main matter itself.
Kindly pass your message.
ಇವತ್ತೇ ಮಾಡ್ತೀರಾ?
Please.
All right, we'll see. If possible, we'll take it up today. I will list it for admission.
Please, madam. Next week, any date, please.
Our roster
ಇದು ಇಷ್ಟೇ ಸರ್, ಇಲ್ಲಿ ಡಾಕ್ಟರ್ ಡೇಸ್ ಡಿಪಾಸಿಟ್ 30.
Roster is 23-24. Roster is 23-24. So it will come up. I list it next week.
Please, madam.
Because I don't have earlier to 23. It will come up for here.
Please.
On that day, I will.
Even otherwise, doctor deposit 32%. Entire ತೊಗೊಂಡಿರ 11% 10% ತೊಗೊಂಡು ಮಾಡಕ್ಕೆ I have no objection.
Matter is admitted. List for hearing. All next week on date could put it so that it will come on a date. Put this in the file.
ಅದು ಫೈಲಲ್ಲಿ ಇರಲಿ ಸರ್ ಮೇಡಮ್.
ಇದೆಯಾ?
ಅಲ್ಲ, I got one copy. The file, let it be in the file. The judgment kept in the file, please.
All right. Yes. Prakash MH.
Your Lordship, I appear on behalf of the appellant.
For
Your Lordship,
response for
what has happened is inadvertently I filed a memo for dispensation of R2 wherein pay and recovery was ordered, Your Lordship. I may be permitted to not press the memo and I'll take notice to R2, owner of the vehicle, Your Lordship.
You filed anything? Have you filed anything?
Yes, Your Lordship. Last occasion, senior had appeared and he's given a record saying R2 may be dispensed. So I may be permitted to not press the memo and take notice to R2, Your Lordship.
Have you filed a memo to say so?
Please, I will file it.
How you can file a memo? You have already got an order of not dispensation. You have to recall that order.
I'll file an application.
Recall that 3-3 order.
Please, Your Lordship. I'll file an application.
Nimgene our objection illa. You file a memo. now.
Please, madam, we are not.
The counsel for the appellant files a memo that due to inadvertence. A memo was filed earlier taking dispensation of notice to R2 in view of the fact that the pay and recovery was ordered, correct?
Please, Your Lordship.
The presence of R2 would be required. Therefore, the order dated 3/3/23 dispensing notice to R2 is hereby recalled. A week's time is granted to the appellant to take out notice to R2.
Obliged.
Appear
KSRTC
for appellant, madam.
R1.
Not-
Vijay Kumar. The
Please, madam.
learned counsel. Shri D. Vijay Kumar is directed to take notice for R1 corporation registry to show his name in the cost list, copy to be furnished. IE 1 of 23 for delay is condoned. Is allowed. 519 days is condoned. No interest.
Without interest.
Delayed period. Copy to be furnished.
Yes,
What do you-
ma'am. Yes, ma'am.
Suma. Issue notice. Stay in, but there is no application for stay. You notice to respondents on main and IE number 2. Issue notice. Main and IE. One more order. Registry to rectify IE number 2 of 24 as IE for impleadment and not for stay. Yes,
Well, 27 to.
Sir,
26.
it's a case of KSRTC appeal, my lord. Facts are such that the claimant claims that there was an accident, but he has not produced any scrap of paper show that he was at the accident site. Subsequently, the discharge summary produced by the claimant is not of the accident.
You notice in consideration of IE for delay, IE for stay is taken up. There shall be stay of operation execution of the order dated 2/4/24. MVC 4281 of 21. Passed by 18th Additional Judge, Court of Small Causes, MACT Bengaluru. Subject to the appellant depositing 50% of the award amount to the tribunal.
Please, my lord.
In 4 weeks from today. Umesh,
Well, 27 to 30 are connected matters, my lord, arising out of the common accident. My lord, the claimants have not even produced the charge sheet, my lord. It is a negligence and quantum 50% negligence. Charge sheet is also not produced, my lord. 50% negligence is attributed to me. I'll deposit 50% of my liability before this court, my lord.
how much is fixed on you?
50%.
Issue notice to the respondents. Pending consideration of IA or delay, IA for stay is taken up. There shall be stay of operation execution of the impugned order dated dash in MVC number dash class 5 MACT and second additional senior civil judge Udupi. Subject to appellant depositing 50% of his share of the compensation within 4 weeks from today. Before the tribunal.
My lord, I would prefer, my lord, because there is no document to show that there was any liability, like negligence on the part of the vehicle, my lord.
Hell ಮಾಡ್ತೀರಾ before this court?
ತಮ್ಮಂದೆ ಮಾಡ್ತೀನಿ, High Court.
Before this court.
Obliged.
I mean, all these 27.
Format, same court, same accident.
MVC number change at the first.
Climate petition. The IA number 2 is the dispensation is not pressed, my lord. Certified copy is already filed.
IA number 2 is dismissed as not pressed.
Not pressed, my lord. The IA number 1 is the delay, my lord.
Your claimant.
Claimant appeal.
Issue notice to respondent, please. Sanat Kumar.
Yes.
Anjula.
Copy was served upon my clerk and I was under the impression that the notice has been ordered. I had sent it and company has sent the wakalat to me.
For R2.
Wakalat will kindly be.
Who's R1? R1 yaar idral.
R1, one or one, notice has to go. He has to file an appeal.
R1 and R2.
Owner has also filed an appeal.
Counsel for R2 has filed wakalat. Same is accepted. Yes. Copy to be served.
Please. Note R1 to, notice to R1.
Notice to R1, our copy kodi.
Please.
There's a special leave.
Claimant, my lord, died, my lord. The my lord, appellants are the legal heirs of the claimant, wife and children's, my lord. Therefore, my lord, I seek leave of this court to file the present appeal. And my lord, and also I filed LR's application, my lord. Kindly allow the leave application and LR's application, my lord. And notice is required to be issued to the respondent and delay application, my lord. It's a case of injury, my lord.
Oh. So after the accident, he's passed away, is it?
My lord, not for the accident, my lord, so far as my lord, as per the judgment of Supreme Court, my lord, so far as other writs are concerned, my lord, the claimants are entitled for enhancement, my lord. They are seek for enhancement.
What happened to the original claimant?
He's died, my lord.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು. So because he has died, you have
Right.
come on record. You
Please,
have
ma'am,
come
please.
on record.
Please. Subsequently, he died. After order of MACT,
Huh.
he died. Order of MACT died, my lord.
After how many years?
No, it's not, Lord, the order passed, my lord. 21, my lord, he died on, my lord, 24/9/21, my lord. 24/9/21. Judgment, my lord, on 3rd September 21, my lord.
Correct. But is it your case that now you are seeking that the death is occurred due to the accident?
But I am not seeking, my lord, I seeking for announcement, my lord. Seeking for announcement, the announcement awarded by the tribunal on the other rates are very low.
So you are not claiming that the death is occurred due to the accident.
I am not claiming that, my lord.
What is your locus
That's why I said, my lord.
that he has to hear?
No, the Honorable Supreme Court, my lord, on that issue has decided, and the legal aids are entitled to claim benefit, other benefits, and this court also, by considering the judgment, my lord, held that.
We'll consider, we'll issue notice and then.
Please, that's why, my lord.
Issue notice.
So far as, my lord, leave application and
All issue notice on main IEs.
so far as petitioner respondent number 1 is concerned, my lord, I seek dispensation, my lord. I'll file memo.
Notice to R1 is dispensed.
Please, my lord.
Issue notice to other respondents.
In this case, IP for the second respondent.
I file memo for dispensation notice to R1, my lord.
Notice to R1 dispensed.
My wakalat may be accepted.
Notice to R2 may not be required as R2 is wakalat is filed by learned counsel BC Shivanne Gowda for R2. Same is accepted. Copy to be furnished to learned counsel for R2. IE 1 of 24 is.
Copy is already served.
Howda?
Please.
1 of 24 is allowed. Delay of 330 days condoned. No interest for delayed period. Post R2 acknowledges the receipt of appeal memo.
Owners appeal, my lord, the negligence and quantum, my lord.
Issue notice, please. Pending consideration, IA for delay, IA2 is taken up. Shall we stay? Order dated 3/7/24, MVC 883 of 20, passed by Senior Civil Judge, MACT Belur, subject to the appellant depositing 50% of the award amount
Before the trial.
for the tribunal
Tribunal,
within 4 weeks from today,
6 weeks.
6 weeks from today.
Please.
So this is, there is a delay of 111 days by case,
KSRTC.
appeal by KSRTC.
Issue notice pending IA for delay. Stay of order. Dated 29/4/24. MVC 2045 of 19. Passed by Additional Senior Civil Judge MACT Srirangapatna. Subject to the appellant depositing 50% of the award amount before the jurisdictional tribunal within 4 weeks from today. Next.
Yeah.
Adrallu same
Similar.
order. The next.
That also similar.
Same. 37, 38.
Would it be one submission and all these, would it be 6 weeks deposit?
6 weeks.
By the time I get that certificate, certified copy and sending it to the takes some time.
Yes. Nagaraj,
In this case, I am seeking dispensation of notice to the respondent number 4 and 5. They are the drivers of the KSRTC bus and also the offending vehicle. I am seeking Your Lordship's kind intelligence to grant stay order subject to deposit of 50% of the amount. Liability of the corporation is 30%. Out of that, I will deposit 50% before the tribunal.
notice to R4 and R5 is dispensed.
R4 and R5 are the drivers of the KSRTC bus and offending vehicle.
Issue notice to respondents.
1 to 3.
Pending consideration of IA for delay. Stay application is taken up. Shall be stay of the order dated 31/8/24. MVC 4925 of 21.
Please, my lord, I have already deposited the amount, my lord.
Small causes and additional MACT, CCH Bengaluru, 12, SCCH 12 Bengaluru. You have deposited?
Before the tribunal, I will deposit,
Subject to the appellant depositing 50% of the award amount. For the tribunal, in 4 weeks from today.
6 weeks,
6 weeks.
Serial number 40, D. Vijay Kumar.
Vijay Kumar. Notice. Pending IA for delay, stay of order.
Serial number 38.
24/5/24 in MVC 190 of 16. Senior Civil Judge, additional MSCT, T. Narsipura, subject to deposit of 50% the award amount. In 4 weeks from today.
My lord, serial number 40, my lord.
Off party, mother.
My lord, serial number 40, my lord.
Madam, you switch off that mic when you are not in use. 50% of the award amount. On such deposit, the same shall be kept in FD in a nationalized bank. Yes, Mr. Vijay Kumar, yours 50%.
Before High Court, my lord, before High Court.
All right, before this court.
Highly obliged.
Ravi Shankar.
Appellant. Rashid. Claimant died during COVID after 7 years of the accident. And even otherwise taking the account, they award the accidental case. He's admitted in COVID and petitioner also admitted in the examination. They died in the COVID and he sustained a fracture of femur. That too in 9/13. He died on 19th. And there is no nexus between the injury and the death. 7.5 lakhs they award.
Now you are taking out notice to whom? The LRs? What is the
Because of because they already brought on record before the.
on record?
Idara.
Notice. Pending consideration of IA for delay. I shall be stay of the order dated 27/8/24. MVC 684 of 70. Passed by MACT.
Mangalore.
4. Court of Third Additional District Judge. DK, Mangaluru. Subject to deposit
Before this court.
of 50% the award amount before this court within 4 weeks,
Inclusive of statutory deposit.
including statutory deposit.
And that amount may be deposited in any national bank.
Still the 7 lakhs. Said amount shall be kept in a fixed deposit in a nationalized bank.
Much else.
Finish it off.
First respondent.
1 minute, 1 minute. We'll finish list 2 and come back to you. List number 2.
List number 2, my lord.
Serial number 7, notice may, so far as respondent number 1 is concerned, notice may kindly be dispensed with.
Notice to R1 dispensed. Issue notice to other respondents.
Yes, much out.
Serial number 11. And this appeal by the owner of the vehicle. Well, claimant also filed another appeal. Madam. Kindly post this matter along with claimant appeal.
List this matter along with MFA.
MFA number 6193 of 2024. And my lord, the claimant advocate may be directed to take notice. I will serve the copy to him. TC Shivkumar.
Earlier.
Please.
Next. Anybody else? All other matters notice listed too early.
Serial number 46.
List too early the animal.
List 2 ಅಲ್ಲ 1. I'm sorry.
List number 18, list
18.
serial number 18.
Hmm.
Fight to delay was there. Notice.
So list 3 and 4 is total 25. So 3 is total 25. Sir, Vision Karput. Where is Azhar is not here. Azhar is here. You can, if you hide, then I will think you are not here. So I'll finish admission and take up. Madam is also not here.
The junior is.
No, these are fresh matters. Will get over quick. Yes, Gurudev.
Ready. Case of injurement. Only for enhancement. There are 12 of the judgment. The accident is dated 26/7/2021. 26/7/2021. Aged about 56 years. He was doing own business, that is a vegetable vendor. Earning rupees 15,000 rupees. Court has taken 14,000.
14,000.
14,000. The accident is during 21 and 15,000 is the notional income. In para 14, he suffered right humerus with comminution. He undergone surgery. Para 16. He undergone surgery and he was an inpatient for 4 days. PW2 doctor says that he has got disability of 45% to the limb and 15% to the whole body. Court has taken 15% only. And the income has to be increased. So far as his disability is concerned, doctor says he has to undergo one more operation for removal of the implants. And he has got a weakness and a pain in his right arm and elbow. And unable to lift weight. Since he was carrying a vegetable vending business, certainly it comes in the way of his profession. And pain and suffering has to be increased, my lord.
How many days inpatient?
4 days, 4 days.
What is the age?
56 years.
Multiplier.
Multiplier 9.
Correctly taken.
Correct multiplier is taken. Disability also correctly taken 15% and multiplier.
All right.
But the income has to be increased.
An injury ಏನಾಗಿದೆ?
Fracture of right
fracture.
humerus arm.
All right. That's all.
And he has gone surgery and implants are there. He has to undergo one more operation. Doctor says he has got weakness in his
ಕೊಟ್ಟಿದೆಯಲ್ಲ ಅದು medical expense.
ಅದರಲ್ಲಿ pain and suffering 25,000 ಕೊಟ್ಟಿದ್ದಾರೆ. And loss of amenities only 4,000 is awarded.
All right.
And for later period,
Ah,
at least 3 months vegetable vendor, only 1 month loss of income.
yes, next.
And
My lord,
future
PW2
medical expenses, doctor says 60,000, court granted 30,000.
My lord, PW2 Dr. Nagaraj is not a treated doctor. He assessed the disability is higher side. And the fracture, humerus fracture is united. Only income. 15,000 you had.
All right. Record.
Only 4 days inpatient.
I'm just rectify this system into, it's tilted towards like this. What is the wrong with this? People in the system, computer and ಒಂದ್ ಕಡೆ ತಲೆ ಟಿಲ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನಾವು ಹಂಗೆ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. This appeal is preferred by the claimant being dissatisfied with the inadequate compensation awarded by the Motor Accidents Claim Tribunal, 5th Additional Judge, CH-20 Mayor Hall Unit, Bengaluru. Full stop. New paragraph. It is the case of the appellant that on 26/7/2021 at 6:30 PM, when he was walking on the Kashing-Palya Railway Road. At that time, a Maruti Omni car bearing KA-01-B5411 came in a rash and negligent manner and dashed against the claimant, due to which he fell down, sustained grievous injuries. Hence, he filed claim petition seeking compensation. Respondent number 2 remained absent. Respondent number 1 insurance company filed objection statement seeking for dismissal of the claim petition. Full stop. New paragraph. On the basis of materials placed on record, both oral and documentary, tribunal awarded total compensation of 4,27,500
300.
with interest at 6% per annum.
300.
Directed the respondent 1 insurance company to pay the compensation. Full stop. It is this order which is questioned by the claimant before this court, consequently seeking enhancement. Full stop. New paragraph. It is a vehement contention of learned counsel for the appellant that the judgment and award passed by the tribunal of compensation is meager and inadequate. Same requires interference at the hands of this court on several grounds, including that of income to be enhanced, pain and suffering to be enhanced, so also loss of income during later period, and future medical expenses. On these grounds, he seeks to allow his appeal. Full stop. New paragraph. Per contra, learned counsel representing the insurance company contends that the reasonable compensation has been awarded. He sustains the impugned order. He contends that the compensation awarded is just and reasonable. there is no requirement of enhancement on any heads awarded by the tribunal. On these grounds, he seeks to dismiss the appeal. Full stop. New paragraph. I have heard learned counsel for the appellant and learned counsel for the respondent, number one insurance company. The occurrence of accident, involvement of the vehicle, injuries suffered in the road traffic accident are proved and established by production of exhibit P1 to P13. Stop.
Finalizing 1-4.
Now coming to the question of age, avocation, income, multiplier, disability. It is seen that the claimant was aged 56 years as on date of occurrence of accident. The appropriate multiplier is 9, which is correctly taken, does not call for interference. Doctor has been examined as PW2, who was opined disability to an extent of 45% to the right arm and whole body disability at 15%. Same has been accepted by the tribunal. 15% disability is applied, which does not call for interference. Income taken by the tribunal is 14,000. Learned counsel for the appellant submits income is to be enhanced to 15,000 as per the notional income chart. Same is accepted. Income is enhanced to 15,000 per month. In view of the above, the loss of future earning capacity due to disability would be as under: 15,000 into 12 into 9 into 15%.
That 43,000.
2,43,000 as against 2,68,800. Full stop, new paragraph. Towards pain and suffering, 50,000 is awarded as against 25,000. Towards medical expenses, 1,15,500 awarded by the tribunal is retained. Food and nourishment, 4,000 is retained. Conveyance charges, 4,000 is retained. Attendance charges, 4,000 is retained. Loss of amenities, 25,000 is awarded as against 4,000. Loss of income during later period at the rate of 15,000 per month for a period of 3 months, 45,000 is awarded as against 14,000. Towards future medical expenses, 30,000 awarded is retained. Full stop. In view of the above discussions, the appellant shall be entitled to total compensation of rupees 5,20,500 as against 4,27,500. Accordingly, I pass the following order. Appeal is allowed in part. Judgment and award passed by the tribunal is modified. Appellant is entitled to total compensation of rupees 5,20,500 as against 4,27,500, along with interest at 6% per annum. Full stop. Balance compensation shall be paid within a period of 4 weeks from the date of receipt of copy of the order. Entire amount of compensation shall be released in favor of the appellant by way of electronic transfer upon appellant producing relevant bank details on proper identification.
Please, Manoj.
For the respondent number 3 in this case, I pray for time.
Learned counsel for the respondent number 3.
Insurance company.
All next week.
Please, ma'am.
Manoj.
Issue notice. There will be stay of operation and execution of the order dated 16/4/24 In MVC 606 of 22, asked by the Principal Senior Civil Judge MACT Mandia. Subject to the appellant depositing 50% of the award amount
65, my lord.
within
45.
4 weeks from today. Yes, madam, your matter only.
My lord, I appear for the appellant. Liability is challenged. I deposit before the High Court, my lord, 50% of the award amount.
Before this court, 50%. Deposit before this court, madam.
Yes, my lord.
Yes, Ravi,
The appeal on liability, madam. The
notice. Stay. Order dated 6 July 24, MVC 4234 of 21. Asked by 21st Additional All Process Judge and ACGM MACT Bengaluru. Subject to the appellant depositing
before this
50%
court,
of the award amount before this court within 4 weeks
4 weeks.
from today.
Case of injury, madam. Notice has to be
You notice.
obliged.
You notice.
Kind permission, may I file memo for dispensation R1 madam?
Notice to R1 dispensed. Serial number 47.
48, my. I appear for appellant, my lords. This appeal is filed by insurance company challenging the liability, my lords. And we have filed this appeal saying that we are not liable being an insurance company because the claimant is a gratuitous passengers, my lords. We will deposit the 50% of the award amount, my lords.
To notice.
For I kindly request you to grant this stay, my lords, as claimant has also
1 minute,
filed.
madam. Order dated 1/10/24 MVC 947 of 19. Passed by the Senior Civil Judge MACT Nanjan Good. Subject to the appellant depositing 50% before this court. Where you will
Yes,
deposit?
yes, my lords. We will deposit 50% before this honorable court, my lords.
For this court within 4 weeks from today. Yes, any other submission?
5 weeks, maybe the time given.
5 weeks.
Oblige, my lords.
Appellant, my lords. Matter of injury, my lords. Notice may be issued.
Claimant.
Yes, my lords.
So notice.
Please.
Serial number 50, my lord. Quantum is challenged. I'll deposit 60% with interest before tribunal, my lord.
Alright, issue notice. Stay of order dated 31 January 25 MVC 5980 of 23. Asked by the 9th Additional Small Causes Judge Additional MACT at Bangalore. Subject to the appellant depositing 60%
With interest, I'll deposit, my lord.
along with interest before the tribunal.
Before tribunal.
Within 4 weeks.
6 weeks, my lord.
6 weeks
Yes.
today. On such deposit, the amount shall be kept in FD in a nationalized bank.
Much obliged.
Jay Kumar,
My lord, appeal by the insurance company challenging negligence and quantum of compensation.
you
I am
notice.
ready to deposit 50% of the award amount before High Court within 6 weeks.
All right, stay. Order dated 4/1/25 MVC 1148 of 19. Passed by MACT Senior Civil Judge Nanjan Good. Subject to deposit of 50% before this court within 4 weeks.
6 weeks, my lord.
6 weeks. The said amount on deposit shall be kept in FD.
Much obliged.
The insurance appeal challenging the liability, I am ready to deposit 50% before
notice.
tribunal.
Stay of order dated 5/12/24 MVC 256 of 23. 6th Additional District Special Judge and MACT Mysore Subject to appellant depositing 50% of the award amount before
tribunal.
the tribunal within 4 weeks from today,
6 weeks.
6 weeks. Jay Kumar,
Appeal by the insurance company challenging negligence and quantum of compensation. I am ready to deposit 50% of the award amount before High Court within 6 weeks.
all right, same. Issue notice, order stay 5/2/25, MVC 139 of 23. Senior Civil Judge, JMFC Additional, MACT, Channapatna. Subject to the appellant depositing 50% of the award amount before this court within 6 weeks from today. On such deposit, the amount shall be kept in FD in a nationalized bank.
Highly obliged.
Yes, well, yes. Mr. Madam Pratima and Azhar.
Plus 19 minutes or 18, both. There are two matters. One is
19.
19 is, he is not here, no?
not
We'll
here,
take
I
up
don't-
your next matter. Azhar is here.
I'll take it.
Last date, I had produced 2 memos, Your Lordship. No. One was memo of documents, another was second memo of documents.
Now you're questioning IE 13. That's only
13 and 16. 13, I had filed because I was not allowed to participate in the school proceedings except for they demanding fees.
where
The
is
school-
16?
IA number 16.
No, there's only one writ petition.
One writ petition because there was a common order passed on IA number 13 as well as IA number 16. IA number 16 is at page number 155 of my petition. 155 they had filed.
16 is filed by whom?
By the respondent. 13 was filed.
That was filed for
Seeking
petition.
Consent.
Consent.
School admission.
Give consent.
Yes, sir. To Head Start Educational Academy.
All right. So now we are in two IAs, 13 and 16.
Yes.
13 filed by you.
Yes, sir.
For permission to participate in all activities in the
Yes.
school of the children.
Yes, sir.
and to be given information by the school to you.
Yes, yes, and participate in
And
parent
in IE number 16, she wants your consent for admission to Head Start,
Head Start Educational Academy.
Educational Academy.
Yes, which prima facie is not possible. And secondly, it is not in the best interest of the children also because of distance, because of the curriculum. And on the last date, your lordship, not on the last date, before that, what is the convenience that the child will have to shift from IB International, even the other board, what she is suggesting is a mix of Maria Montessori from 1st to 8th and international board, which is Cambridge. It is not Indian board. IGCSE is not Indian. ICSE is Indian. CBSE is Indian, and state boards are Indian. IGCSE and IB both are international. Keeping in mind the distance, what the respondent has suggested is a school which is 17 kilometers away, one side. What we have suggested is 9 kilometers, and in fact, arguments came down to which is better for the child. In their objections.
All right, now I have heard you in detail. Now, madam, do
Let's-
you have any serious objection in IE number 13, which is rejected, for him to participate in all activities of the
Not at
children?
all. Why would I have? In fact, the mails have been sent to him. The school has been communicating. She has absolutely no objections. It will be wonderful if the father can participate. Other than paying the school fees for the elder child, nothing he has been doing
So
other than
that can be
threatening the
allowed with
schools.
a reasonable
I
restriction.
have no difficulty.
So that
if
he
the
doesn't go and create any
create a mess, that is all.
untoward incident,
Threaten
embarrassment.
the school like.
That will pass a
That's-
conditional order.
Yes, other than that, I have no difficulty. He is a father, he is well entitled to for the.
What I'm telling you, the order that will be passed by this court, that he will be permitted to participate in all activities.
I have no
School
difficulty.
shall inform like it informs you
Yes,
equally to him
yes,
by way of email
absolutely.
and other communication.
Yes,
He shall not interfere with the activities of the child, cause any embarrassment either
Yes.
to the
Yes, yes,
children
that's all.
or
obviously.
the
Yes.
mother. In
In
any
the
of the,
minutes, that is the reason I produced last time with a memo stating that there is a user ID created in the name of the child. Both the parents as well as all the parents, in fact, they have to access the user ID and the events all come in that.
all right, now
That
see
is all.
what happens in most of these child custody cases is because of your fight, the college or the school will be put into a predicament.
Correct.
Because you would have given instructions, you better communicate only to
Not
me.
at all. in
He
fact.
would have given instructions, no, I am the better parent. So they will
That's-
be in a fix.
I
So
understand.
now if we make it a constant order, so that they will communicate based on the order passed by this court, which can be furnished on a regular basis by informing both of you. One CC will have to be put, that's all.
Correct.
Yes, in
Because
fact, if there is some application, I may be given access to that. If there is some application like Moodle or whatever they are saying.
Everything,
Yes, yes, sir.
everything, whatever is given to either of the mother
Yes.
parent
Yes.
will be given to the other parent.
Yes, yes. Because in
That is
fact.
on IA 13.
Yes, IA 13. I just would, sorry, that's one. In fact, the reason he could even send the mail saying that I do not give consent is because the school sent an email to him asking for consent. It's
Asking for
not that
fees.
they have not been sending, but anyhow, I'm just submitting that this is what it is. If they were to take only mother's consent
I will
and
note
admit,
down
why
it.
would be fighting Millards?
Your contention is everything is available and given to him.
Yes, that's right.
Now-
Anyhow, I have no difficulty even if the court passes, Millards. Let us regards the
The
IA.
next is IA number 16 of
16.
Head Start and whether the other.
Yes, Millards.
So you have, both of you have not arrived at a consensus.
Consensus, correct.
Pass an order.
Millards, yes, Millards.
Anything
Only one,
for-
with the memo of documents that was filed on the last date of hearing, I have produced a photograph.
What do you
where
want?
The child has visited the Head Start Academy and is extremely happy. Given the chance, in fact, he doesn't mind coming and telling the court, but I know that is not the age to.
Which document?
Millards, on 14/3/2025.
I have that.
The first page is the photograph that the child has
Hmm.
visited the Head Start Academy, which he has to go to, in fact, grade 1. They took all the children for a field trip. And that is a photograph that I have produced. And Millards, at page 4,
Hmm.
Head Start Montessori located within 3 minutes drive. This is for the second child. which is hardly 3 minutes away from the school. And she being 3 years, I don't think they should dispute that also. And this school, my lords, is the same school that was decided by both the parents in consensus with each other. And that also, my lords, I have pointed out at
That is Head Start Montessori.
Head Start. That is the younger one will go to the Montessori section.
That is the second child.
Second child, yes.
Anya.
3 years.
Anya.
Anya, correct. my lord.
Who's 3 years.
Who's 3 years?
Alright.
Going to be 3 years. Very good.
So now you are proposing both the children to go to IB.
Neve, yes.
Neve has got both.
Yes, it has got both. It has got ICSE also. In fact, question of Head Start does not arise because it is giving Maria Montessori, which is not even recognized.
Alright.
And with respect to just few things from the advantages that they have shown, I would take only 30 seconds, page number 8 onwards, their memo itself. Though it is from ChatGPT, I have, what is the problem in this? That also I'll point out, Your Lordship.
Her memo.
Yes, her memo, page number 8. Second advantage, less stress and more enjoyable learning. Says that IB students face heavy workload, assessment, and high academic expectation, which is page number 8.
Which one? One second.
Second point,
Second
less
point.
stress and more enjoyable learning. For Montessori learning is exploratory and hands-on with no pressure from exams or grades. That means there is no examination. IB students face heavy workload, assessment, and high academic expectation. Here we are making students undergo a rigorous test, which is actually good for the children. Next point, no exam, grades, or strict assessment. Montessori says that no standardized test. IB requires formal assessment, research papers, and exams. That means it is giving a holistic, it expects the children to be holistic. Next page, Your Lordship. Focuses mixed age classroom and collaborative learning. Montessori, children of different age groups are put together. For example, if I am an introvert, and if I am of 3 years, or if I am of 6 years, and if I am with a child who's of 9 years, and he overpowers me, or in any sense, then I will never be able to come up. There is another side wherein I may learn good things from him. But if I am an introvert at this time, because there is no sufficient encouragement, so in the class, I will never be able to participate. Sixth, thus focus on practical life skill. Montessori integrates real-world skills like critical thinking, decision-making, and self-discipline. IB is academically focused with less emphasis on life skills. This is actually false, Your Lordship. This is false. We can understand from the next document they have produced, which says advantages of IGCSE over IB. More flexible in subject choice. IGCSE allows students, it is at page number 11, Your Lordship. IGCSE allows students to pick any combination of subjects without restriction. They say they have textbooks. When was the last time that textbook was edited? I studied history of Romila Thapar. In fact, most of them would have studied. There is no timely updation of the textbooks. Here, when they say that there are humanity, the last one, why it's why it's an advantage. Students who want to specialize early, example, focus on humanities. Humanities is all about inquiry, sociology, philosophy. If I study Immanuel Kant, if I study Machiavelli, without knowing the situation, under what circumstances a particular philosophy has written, I will not understand. I'll end up mugging up, I'll end up writing the exam, I'll get good marks, but I will not be able to apply it. Less academic pressure and workload. Again, IGCSE is setting the standard low. So it is creating a student who in future cannot compete with higher standards. If you're in IB, you can always fall back. Better for exam-oriented students. IGCSE assessments are mostly written exams. Written exams, what do they specify? Is it objective? Is it subjective? Or is it viva? Viva is very important. I may be very good on papers, but I may not be able to speak in wherever I'm expected to speak. Next page, at page number 12, sixth point. Sixth point, why it's an advantage, more widely available and affordable under the heading. The decision of by ChatGPT is IGCSE is a practical choice for students in regions where IB schools are not available. In fact, even they admit if IB is there, then it is a better choice. Is my submission.
First, however, the next page, anyhow, I will not. Why I submitted this Montessori comparison with and IGCSE Millards is because Head Start from grade 4 starts their IGCSE level. That is all I would like to say.
It is great.
Not that from grade 1 to grade 12, it's Montessori.
According to you,
Millards,
if Anya is going to that Head Start
Montessori.
Yes. Then Kavin will not be able to go to the same institution.
No.
Millards, that's the shift. That is the reason.
Same
campus. Yes.
A different campus.
Yes.
Under the same umbrella.
Yes.
But that is how far away?
Millards, it's about, I think 16 kilometers.
17
Produce
kilometers.
That also, I think. I'm not.
They have produced it.
Millards, at page.
That is Head Start Montessori is 3 kilometers.
Montessori is 3.
Head Start Academy.
3 minutes, in fact, not even
3
3
kilometers.
3 minutes. Montessori is just hardly.
And both are coming under the Head Start Academy.
Head Start Academy. Yes. Millards.
Whereas his contention is that Neve has got both under the same campus.
No. No school has under the same campus. In Bangalore, if it is an international curriculum, it will not have, because they will make separate pockets in every area. A child as young as 3 years.
The distance of the Neve.
Same in Koramangala itself. It is 5 minutes. Neve kindergarten 5 minutes. 3 to 5 minutes.
Yes.
Same area, Koramangala itself.
So Neve in kindergarten for the younger one.
Yes, Neve early years it is called. For the younger one.
Neve
early years.
All right.
That's
5
again,
minutes.
They have put as 27 minutes. I'm not sure if.
What about the second boy?
Second boy is Neve Academy, which starts from grade 1. That is 9 kilometers. Distance is at page number.
They have put even Montessori as 23 kilometers. I saw.
No, Montessori is 5 minutes, just 5 minutes.
They have not given that, Millards.
To be precise, it is 1 minute, Your Lordship, not 5 minutes.
Which page?
No, I have not produced that.
You have not produced. That's what I said. It's not produced. Produce only Neve Academy. Which
Neve
is
early years,
page
even in fact,
211.
it is in the same block also. 4th block, Koramangala.
This petition is filed by the petitioner father. Agreed by the order. Common order. Passed on IE number 13. And IE number 16. In GNWC number 137 of 2023. by the fifth additional Principal Family Court, Bengaluru. Full stop. Petitioner father and the respondent wife are at loggerheads due to matrimonial dispute and differences of opinion. They've initiated child custody petition in GNWC number 137 of 23 by the father. And in the course of the petition, two applications came to be filed, one by the father and the other by the mother. IA 13 came to be filed by the father, seeking for the following reliefs. Extract page 126.
This 126.
IA 16 came to be filed by the mother, seeking for the following relief. Extract page 155. Stop. Paragraph, new paragraph. On hearing the learned counsel for both parties, that is the father and the mother, the learned judge of the family court dismissed both the applications.
No. Dismissed 13, allowed 16.
I dismissed IA number 13 and allowed IA number 16. Consequently directed the father to give consent for admission of the minor children for grade 1, the first child, and pre-primary to the second child in Head Start Academy, Educational Academy. Full stop. It is this order that is questioned by the petitioner father. Full stop. New paragraph. It is the vehement contention of learned counsel for the petitioner father that the family court has failed to take into consideration several aspects while dealing with both these applications. It is contended further by learned counsel Sri Azhar that the family court has, without application of mind, passed a mechanical order contrary to the welfare and the well-being and interest of the minor children, and has not taken into consideration the relevant material placed on record, including the growth, the future career, and the curriculum and the syllabus, which would be in the best interest of the minor children.
Distance.
Full stop. Learned counsel further contends that the family court has also not taken into consideration the distance of travel to and fro from home to the school. And the hardship that would cause to the minor children in traveling to a school which is 16 kilometers away
17.
from their
60.
home on a daily basis, and thereby wasting precious time on causing a daily disturbance for travel, considering the traffic conditions in Bangalore. Full stop. It is also contended by learned counsel for the father that the school authorities have not been communicating to him with regard to the entire school events, curriculum, activities, informations, and other requirements of the minor children on a regular basis. And he has not been receiving the required communications from the school with regard to the events and the decisions that are being taken with regard to both the children. So also with regard to the parent-teachers meeting, access to the school records, the progress of the children, and any other event that occurs pertaining to the children in the school, and also co-curricular activities. It is his grievance that the respondent mother is taking unilateral decisions with regard to both the minor children, including changing the school of the children, putting the children in a particular school without consulting him, which is not in the welfare and well-being of the minor children and their future growth and career prospects. Full stop. New paragraph. Learned counsel further contends that in view of the unilateral decision taken by the mother, the father has been excluded from important information pertaining to the education of the minor children. And the unilateral decisions taken would certainly hamper the growth and development and prospects, career-wise or otherwise, of the minor children. It is also contended by him that the children would have to be sent to a school which is safe in view of several incidents that has happened in the recent days with regard to harassment to the minor children. So therefore, a responsible school and a school with repute will be the best for both the children, rather than sending the children to a nearby school or a faraway school at the whims and fancies and unilateral decision of the mother, or for that matter, leaving the children in the care of a nanny or a driver to drop children to these schools. Learned Counsel further contends that it is the father who has been paying the educational expenses of the school, so also other expenses including maintenance for the minor children, which he does not have any grievance and he would continue to pay whatever be the expenses and the tuition fees and co-curricular activities expenses for the minor children. He further contends that the primary concern of the father is to take care of the well-being and interest of the minor children, both with regard to educational needs and that of other co-curricular activities for proper growth development, both emotionally and psychologically and physically of the minor children, and to give them the best education by enrolling in the best school in the city so that they can become good citizens and are able to compete with the other children in the country as well as in the international arena. Full stop. It is further contended by Learned Counsel that the father is interested in putting the children to an international board curriculum, whereby even if the children were to move to another country for the present or in the future for higher studies, they would be able to cope up with the international board rather than creating an alienation or difficulty in transition from one board to the other. He is willing to take care of the entire financial expenditures of the school in the international board. All these aspects have not been considered by the learned judge of the family court while considering application IA number 13 and as well as IA number 16, and has mechanically disposed of the application by rejecting IA number 13 and allowing IA number 16. Full stop. New paragraph. Learned Counsel further contends that while allowing the application IA number 16, the court has not taken into consideration the distance of 17 kilometers of the new school, which the respondent mother is intending to admit the older child. In a city like Bangalore, where the traffic is terribly bad and it consumes a lot of time in traveling from one place to the other, especially during the peak time, it is always advisable to put the children to the nearby school, of course, the best school for the welfare and well-being of the children. Therefore, he contends that sending the child to a school which is 17 kilometers away may not be advisable and it would be cumbersome and tedious and hardship would be caused to the minor child on an everyday basis during travel itself. It is also contended by Learned Counsel that he draws a difference between the school run under the IB curriculum and that of the school under the
Maria Montessori and IGCSE.
Maria Montessori and IGSC.
IGCSE.
School. Full stop. He has placed several materials before this court to show the differences between both the schools and how the IB schools would be better suited for the children to cope up for the present and also for the future, and better facilities are available in the school suggested by him namely Neve Academy, compared to the one suggested by the respondent mother, that is Head Start Educational Academy. Full stop. On these grounds, learned counsel contends that it would be in the interest of both the children that they are put to the IB curriculum in a good school so that they can develop their personality as a good citizen, cope up either in the country or all, or for that matter in the international arena for their future growth and prospects. Accordingly, he seeks to allow his petition and allow IA number 13 and consequently reject the application filed under IA number 16 and permit the children to be admitted to Neve Academy, which is an IB curriculum course. Full stop. New paragraph. Per contra, learned counsel Srimati Pratima, appearing on behalf of the mother, contends that the school has already been communicating with the petitioner father, publishing and communicating all informations pertaining to the minor children, to which the father has been responding and replying. Materials are already placed before this court, which is apparently evident that he is not kept aloof or not alienated from these school activities of the minor children. And the reply sent itself is evident of the fact that he is receiving all communications from the school with regard to the minor children. Full stop. She fairly submits that she would not have much objection in the school communicating the activities of the minor children, including that of participation of the father in any of the school activities, the parent-teachers meeting, and the records and access to the records and progress, either physically by registered post or through emails by electronic manner. She further contends that this is that the school has been already communicating, and a false statement is made by the father that he has not been communicated, and materials are placed before the court to evidence this fact. Be that as it may, she does not have any objection in the communications being sent by the school to the father on all activities of the minor children, including the school activities and that of activities conducted outside by the school of co-curricular and extracurricular activities. Full stop. New paragraph. Learned counsel for the mother further contends
Para 9, page 130.
that the older child, Kavin Chandrasekhar, was enrolled to Head Start Montessori House of Children. And he has been regularly attending the school and doing extremely well in various activities. To support the same, she has produced annual report card for 2023, and also the attendance records. In view of the older child, Kavin, going to a grade 1, namely the Head Start Educational Academy for the year 2025-26, the admission process has already commenced. It would be in the interest of the minor child that he is admitted to Head Start Educational Academy, which is similar to the one which he was earlier going, which is a Montessori House of Children. The older child, Kavin, has already gone to the Head Start Educational Academy, visited the school, and he's conversant and happy with the school. Full stop. Therefore, she contends that it will be in the interest of the minor children, both the children, that they are studying under the Head Start Education Academy, one in the Montessori and the other one in the Head Start Education Academy, which is based on the IGSC curriculum, which caters both to the national standards as well as international standards. In case they would want to switch to another board later on in their life, the transition would not be difficult while moving from the IGSC to IB curriculum. It is also contended by learned counsel that there may be a slight variation in the distance of travel, but it is during these travel time that the children will get close to the other peer group and enjoy and have a good camaraderie with the other peer groups. So that should not be the ground to reject the children from going to a school which is a little distance away from the regular school. Full stop.
So that's one point is both the parents choose this school. That's all.
Both the parents?
Choose this school and had that one point at para 9, which they themselves said. I'm sorry.
Learned counsel further contends that the present school of Head Start Academy was chosen by both the parents, and accordingly the children were admitted to these schools.
Head Start Kindergarten, Head Start Academy.
Learned counsel for the respondent mother has placed certain photographs along with a memo. And a write-up and short notes with regard to advantages of Montessori over the IB. In which it is shown that the Montessori schools are better compared to the IB curriculum as it emphasizes holistic education. But admittedly, there is a difference significantly in their approach. The council further contends that in the Montessori, they are more flexible, student-centered and stress-free, whereas the IB is structured, rigorous and academically very demanding. Thereby, learned counsel contends that the Montessori and the IGSC curriculum would be better compared to that of the IB for both the children. That is preschool and primary levels, as it benefits from exploration, creativity, and stress-free learning environment rather than a rigorous, structured and academically demanding IB curriculum. There are several notes produced by learned counsel for the respondent mother showing advantages of IGS CSC over the IB. Like more flexibility in subject choices, less academic pressure, better for exam-oriented students, easy transition, more widely available, less stress and more balance, etc. On these grounds, learned counsel for the respondent mother contends that the order passed on IE number 16 is sustainable and is correct and does not call for any interference, as the children would be in a better position if they study in the same Head Start Academy school rather than going into an IB curriculum which is more structured, rigorous, and demanding. Therefore, the direction given to the petitioner father to give consent does not call for interference, as it would be in the interest of both the children to study in the Head Start Academy, one in the Montessori and the other in the Head Start Educational Academy. On these grounds, she seeks to dismiss the petition referred by the petitioner father. Full stop. Next, new paragraph. I have heard learned counsel for the petitioner and learned counsel for the respondent. Let me deal with these applications independently. Firstly, IE number 13. This application filed by the father is for seeking permission to participate in the parents teachers meetings and to be updated on all aspects as a parent and to have access of the children's school records, progress, to be included in the correspondences made by the school on all events, and to permit him to take decisions along with the respondent mother jointly in respect of both the children. And to permit him to attend to the parents teachers meeting and to be included in all school correspondence by way of email and all important and necessary decisions to be taken with regard to the children's education and also their future career pertaining to education. Full stop. This application has been dismissed by the learned judge of the family court. After having heard learned counsel for both parties on this particular application, I do not find there being any serious differences of opinion in both the parents in the school providing access, communications, inviting the parent for a parent teachers meeting, access to school records and progress of the children, and communicating all details or any necessary details by way of email correspondence to both the parents. In fact, learned counsel for the respondent has fairly submitted that she would not have much objection in these communications being sent to the petitioner father. Under the circumstances, this application deserves to be allowed. Accordingly, it is allowed. All communications from the school to the petitioner father shall be communicated by way of emails or by way of hard copies through post. He shall be included in all events related to the minor children. All communications with regard to the progress and update of the minor children shall be communicated to the petitioner father by way of email correspondence, including their progress, attendance, activities. So also with regard to any decisions that are being taken shall be communicated to the petitioner father for him to jointly participate along with the respondent mother for the welfare, well-being, proper growth, development of the minor children. Full stop. New paragraph. Coming to the aspect of IA number 16, where at the instance of the respondent mother, an application was moved for a direction to the petitioner father to give consent for admission of the minor children for grade 1 and pre-primary in Head Start Educational Academy. The same having been allowed is questioned before this court. Full stop. As a matter of fact, it is not in dispute that both the father and the mother want the best education to be imparted to the minor children. And in pursuit of the same, both of them want to put forth their opinion for proper development and growth of the children with regard to admission to a particular school. According to the father, it is the IB school or curriculum which should be in the best interest of the minor children. Whereas according to the mother, it is the Montessori and the IGCSE which should be better in the interest of the minor children.
Your Lordship, that is IB and ICSE. NEEB is IB and ICSE, both are there.
That is his canvassing today. It is not there in the history.
Both the parents have placed several material before this court to canvass their arguments as to which is the better curriculum school for the children to be admitted. On a careful analysis of the documents placed before this court, it is relevant to see that what would be in the best interest of the minor children rather than what is in the interest of the parents. The aspects that would have to be considered while admitting the children to the school is the distance of the school from home, the travel time from the school to the home, back, and to and fro. So also the future growth, development and prospects in case the children want to move out from one curriculum to the other or from one state or country to the other. Apparently, it is seen that the father has been paying the entire educational expenses of the minor children,
Only one son, not.
and he continues to pay the same and would continue to pay the educational expenses of both the children, along with the maintenance other than the educational expenses.
That is in dispute actually. Although I am paying, because that is not decided by DV court. It is still ad interim order.
But you said that you are going to pay for the welfare.
For the children, yes, for the children, yes.
Not talking about the wife.
Yes, yes, for the
You're only on the children. The the school suggested by the mother, that is the Head Start Educational Academy, apparently is 16 kilometers away from the home. Whereas the school suggested by the father, that is Neve Academy, appears to be 9.3 kilometers from the home of the mother.
From home of the father. From home of the mother, it is 9 kilometers. Page number.
Kilometers from the home of the mother. So also there are several activities that are seen in the document produced by both parties, that the events, the space, the laboratories, and other co-curricular activities are more in the IB Neve Academy rather than that of the Head Start Educational Academy, as per the documents produced by the parties. It is also seen that the fee structure is also higher in the Neve Academy than in the Head Start Educational Academy. Be that as it may, the petitioner father is willing to bear the entire educational expenses, even if it is enhanced or increased on a year-to-year basis. And that being the case, it is to be seen what is in the best interest of the children. If the father is willing to bear the educational expenses to put the children in the best of the school, it is always better to put the children in the best of the school to compete with the best in the state and the country. And also, if at all they would want to move for higher studies abroad, it will not be a difficulty during transition. Full stop. In view of the discussions made by this court, it appears that the Neve Academy suggested by the father may be a better option for the children to be admitted to rather than Head Start Academy, which is at a distance longer than that of, farther than that of the Neve Academy, and better facilities and activities and co-curricular activities being available at Neve Academy, including the infrastructure. It would be in the better interest of the minor children to join the best school if it is possible for the father to bear the expenses all through. Under the circumstances, without going further into detail as to which of the academy is better, for the time being, it appears that the Neve Academy suggested by the father would be a better school to admit the children than the Head Start Educational Academy. Full stop. This court is conscious when it's making this order. This court is not deciding as to which school is good in its educational performance, as this order should not determine or is never intended to say so. Considering the proximity of the house of the parents, both father and mother, it would be in the better interest of the minor children that the children are admitted to Neve Academy and the father willing to bear the educational expenses. It is advised to admit the children to Neve Academy rather than Head Start Academy. Under the circumstances, I pass the following order. Petition is allowed. The impugned order passed by the Principal Judge Family Court, Fifth Additional Principal Judge Family Court at Bangalore in GNWC number 137 of 23 on IA number 13 and IA number 16. Is hereby set aside. IA number 13 is allowed. And IA number 16. Hereby dismissed and modified as under. Full stop. The petitioner father shall be permitted to participate in the parent-teachers meeting, shall be updated on all aspects as a parent by providing access to the children's school records, progress, and shall be included in all correspondence and shall be invited to parents-teachers meetings, and he shall be included in any decisions that shall be taken with regard to the minor children in the school and concerned to the school activities. The petitioner father shall be updated on all aspects as a parent and have access to school records and progress by way of communication through email correspondence by the school. And he shall be included in all decisions that are to be made with regard to both the minor children. Full stop. Next new paragraph. In view of this court dismissing IA number 16 on hearing both the learned counsels on the admission to be made to the minor children, the minor children shall be admitted to Neve Academy. And the petitioner father shall bear the entire educational expenses, co-curricular activities and other miscellaneous expenses entirely of both the children. Full stop.
That's apart from the maintenance being paid to the respondent, because nowadays they are minusing that, they're deducting the amount.
Oh, this is only educational expense.
No, yes, correct, but
So separate,
but since they have filed deducting and then
is there a separate maintenance ordered?
Yes,
To her, there is a
1,25,000
separate
I am paying,
to her which I have produced.
which is for children as well as the as well as the mother. So I have adjusted that for 2 years. I have adjusted because I have paid the fees.
No, that's
So-
not right.
Right, as of now, you're not here challenging any maintenance.
No, I am not challenging that.
So if you want to challenge that and modify that, you are at liberty to do
Yes,
so.
yes.
Milats one. That has been challenged, that has been dismissed. He's suppressing at page 33, Milats.
Your
If I may
lordship,
just
that is
point
ad
out,
interim ex parte order. There is no final order passed on it.
Page 33.
Page 33.
Hmm.
Is the writ petition wherein the maintenance order was passed at page 35, Milats, at para number 6.
Page 35 is,
Of my, of my application for vacating stay. I'm extremely sorry. They have not produced that.
yes,
Let's page 35.
yes.
Sixth para. In the light of the above pending consideration of any application that may be filed seeking for interim, petitioner husband shall pay a sum of rupees 1 lakh per month to the respondent wife till the disposal of the said petition. Plus, this again went to Supreme Court, which is again at annexure, page 30, I'll come to the relevant portion. Page 38, my lords, right next.
Yes.
38, the Supreme Court clarifies that the order of the forum, my lords, I'll read the last 4-5 lines. The order of the forum under 2005 Act would become operable and the sum of rupees 1,25,000 would be the monthly interim maintenance. The petitioner shall be at liberty to challenge the order of the forum under the Act, proceeding on the basis that the awarded maintenance is rupees 1,25,000 per month. This they went on appeal and that was dismissed. The order has not been produced.
Your Lordship.
However, they filed another application for setting aside this order in the same court after dismissal of the appeal that needs adjudication still. So this is awarded to the wife. So they cannot minus this amount because that is what they've been doing and producing here. That's when I got to know.
It is not awarded to the wife because, Your Lordship, page number 38, it says that the DV Act will be read as 125. I have the DV order. Just for reference. In fact, High Court order was stayed.
Yes.
Plus in DV.
This is the DV order,
A sum of
which
25,000
was given.
to the wife and children. That is why this 125.
Then they
Assigned
said-
to the wife here. There again, I thought because he was not paying, I approached the DV court and filed an application. A sum of rupees 25,000 in addition to 1 lakh came to be awarded. Now that is why this clarification by the Supreme Court, my lords, that
By
1
the,
lakh
by the
25,000.
DV court, by the DV court.
DV court was 25,000.
So 1 lakh by which court? By the.
High Court.
DV court, my lords.
That is stayed.
That,
That is stayed in the same order.
stayed.
At 1, 2,
That
3,
is
4,
not stayed,
5th.
my lords. I think
Fifth.
they're highly, I don't know
Fifth
what they're
line.
saying.
In the event, we stay that part of the order of the High Court. And they say you read this page number 38
38.
Yes,
in the
yes.
middle of the,
Of-
5th line.
Supreme
1, 2,
Court
3,
order
4.
is what
Supreme
they
Court
say.
order. In the event, we are to stay the part of the order of the High Court. And this order, the DV order is read as 125 and you challenge it, they said.
In the event, we are to stay that. part
Yes,
of-
1 lakh is stayed.
It's not stayed. I don't know what he's submitting even.
And this,
And this is disposed of. Supreme Court is, this SLP is disposed of.
and this order is read as 125 now.
Hmm.
The DV Act. And DV says it is for both, respondent number 1 is directed to pay 25,000 per month towards interim maintenance of petitioner and her 2 children from the date of this petition. So this 25 has to be read as 125 so that I can challenge it.
That was challenged and dismissed.
Because this is an ex parte order. There is no final order passed on this.
That's whatever it is, the clarification.
This is ad interim ex parte order issued at the time of notice based on a false affidavit.
Educational expenses should not come.
All
under
right, you
this.
go and challenge it.
Yes, I am under the process because this finding should not come as an embargo. I am ready to pay the educational expenses of the child, the expenses of the child also.
Not
With
child,
respect-
children.
Children, sorry. With respect to the wife, I am disputing.
Madam Pratima, on page 38,
Yes, my lords.
the order of the forum under 2005 and just about 4 lines above.
Yes, my lords.
Order of the forum under
Forum,
2005
yes, will
Act would
become operable and the
operable.
sum.
The sum of 1,25,000 would be the monthly interim maintenance.
Correct,
Petitioner shall be at liberty
correct,
to challenge the order of the forum
correct,
under the 2005 Act,
correct.
proceeding on the basis that the awarded maintenance amount is 1,25,000.
Yes, ma'am. They did appeal.
Huh?
They did appeal.
Where is that?
I have not produced,
No, no.
neither have they. I have it. I can get it, my lords.
So what
That
has-
is
that- that-
appealed
that
and
time-
that is dismissed. Their appeal is dismissed.
Dismissed on merits.
No, on condemnation of delay.
My lords, what happened is after this.
No, that anyway you deal in a separate.
Yes,
forum.
yes.
Correct,
I am,
that's
I am,
all,
that
that's
is,
all, my lords. I
I have
just
not said
wanted,
anything
because
about.
they have been deducting and paying, that is all my, because
am
they should
not
not
dis-
say
I
tomorrow,
am-
Neve's fees is this much, I will deduct it from the maintenance, that is all, my class, because
that
your
we
lordship
can
had
do
asked them
this
to
has
file an
become a
affidavit if you're
petition more about money than about the interest of
not,
children.
nothing to do with the money.
Then,
Because in fact, your lordship recollects, they are yet to file an affidavit, my lords, before this court, saying that he will be paying the fees if your lordship recollects. That was a affidavit that they were
By
supposed to
now,
file
by
today.
virtue of my order, he is now, there's an order of the court that he
Yes.
will bear.
yes,
the
yes,
entire
I will
educational
bear, I am not.
He will pay it. So I have not discussed anything with
Yes.
regard to the maintenance.
No, no,
of-
that
of
is,
wife.
no. Why I said apart from the maintenance is because it should not get confused with the maintenance and the fees. That is exactly what he's been doing, Milords. He's been
Okay.
reducing the fee that he has paid for Kavin and paying the maintenance from past 4 months, which
This
is not.
is only with regard to IA 13 and IA 16.
Yes.
So I have categorically said so. There's no ambiguity involved. here.
Yes, yes.
Because there was a line.
He
Milords, the
doesn't
father
pay, you
shall
can-
pay these fees of for both the children, but not apart from the maintenance. That is all I.
I have not discussed anything about the other wife's
sir.
maintenance. So also the children, other maintenance,
Yes, yes,
apart
yes.
from educational expense.
All,
Yes.
no.
Whatever is orders are available in your favor, you can execute it.
Yes.
If liberty is given to him, he can.
I
carry
can-
He did not file, if at all he had filed an affidavit, probably that could have been produced wherever he took this thing that the fees is also included in this, because he was supposed to file an affidavit today.
That I do not want to touch upon. Yes.
All right, great.
Your Lordship, the last portion, if it could be included, if she is not consenting, then I may go ahead with the admission.
No, I have categorically said that now you go and admit the children to Neve Academy.
Because again, if they say consent of the mother is
All right,
not,
work out. In view of this court passing an order of admitting the children to Neve Academy, consequently, the respondent mother shall provide consent to the father, and together or separately, they shall file necessary application for admission of the children to Neve Academy in their respective pre-primary or
yes,
what is it?
pre-primary and
One,
Neve Academy and Neve early
Grade one,
years.
grade one.
Neve early years
No,
and
no,
grade one.
One is pre-primary, other
Yes.
one
Yes.
is going to grade
The
one.
one is
Yes.
grade
Grade
one.
one.
I'm not sure whether, because the
Wherever it
school
is.
has IGCSE and IB, I'm not sure which they want to.
Yes, wherever it is.
Much obliged.
Yes, Venkatesh Arbatti.
Yes, ma'am.
Now you filed.
Filed, not filed. Also, Leonard Senior has filed, not objections also have received.
Objection you have received.
Yes.
All right, you
We have filed objection, my lord, for both the applications.
have it next week then? You
Yes,
can
ma'am.
argue. What is the great urgency now that is something is coming up, stopping you from proceeding against him, this order?
This interim order.
But what is it that now you are initiating after 10 years?
We have already filed not application for cancellation of bail.
Cancellation of bail in which proceeding?
Before the Leonard court in the CCH 82, ma'am, the trial court, where the anticipatory bail was granted.
I'll also go through it. I will have it on Monday.
Yes, my lord, that unseated bail petition also one of the annexure, your lordship.
In
That
his
we have enclosed to the petition.
You have annexed?
Yes, yes. It is at page 132, my lord.
Or in the main petition itself?
Yes, main petition itself. That is the foundation, my lord.
All right, I'll see. Let me also go through it. Please list it on Monday, you can argue. So only thing what you are requiring is a modification of this order,
Only that
which
last
does not affect you from prosecuting the
Only
other
that-
matter,
Yes, yes.
which is coming in between according
Only
to.
that last part. Not, it's an innocuous request. Ma'am. Is
Here-
my respectful submission, of course.
Here, my lord, this FIR is
There is
the
no
basis
challenge.
for cancellation of unseated bail.
This, sorry?
The FIR what we have sought for quashing, my lord, in this petition is the basis for cancellation of unseated bail. My lord, if it is allowed, my lord, that they go for cancellation of unseated bail. My lord, this petition will become infructuous. My lord, our contention is this FIR is an abuse of process of law. If it is quashed, my lord, that will not survive.
So indirectly, he will benefit
Yes,
by.
yes, yes. My lord, here the question, my lord, that the allegations made in this petition, my lord, in this FIR is totally unconnected to the investigation that has been carried out, my lord, about 10 years back. Unseated bail is totally unconnected. But they are seeking, my lord, only ground is he is involved in attacking the investigation officer. The complainant is not the investigation officer at all. And investigation is completed, your lordship. Charge sheet is also filed to the court. It is not only to the sanctioning authority that is charge sheet is submitted. Charge sheet has been filed to the court. And it is pending before the court. Investigation is not pending. He is no longer an investigation officer. Question of threatening him, forbear from the doing your official act,
my lord, does not arise. That is the only ingredient, my lord, of 224 IPC, 224 of BNS, that any public servant threatened to forbear from discharging his official duty. My lord, here the allegation is, since he was the investigation officer, he was the head of the investigation unit.
But now the charge sheet is filed, where is the question of?
That is, my lord, the entire case is only, our contention is from the beginning it is, when they have completed investigation, filed the charge sheet, where is the threat for him not to file a charge sheet? The ingredients of 224 does not apply. Therefore, it is an abuse of process of law. The very registration of FIR itself is an abuse of process.
All right, Monday we'll have it. You can argue. Nimdi, you have any?
All
other-
arguments.
We
are
have, in
valid.
fact, my lord, I beg
So
to
you are
differ.
supporting the loci?
I'll have to support my lord, because on 2 counts, my lord. My lord, and the senior friend is, my lord, is not correct in saying that he's not investigation officer. He is the investigation officer by virtue of section 36. He becomes investigation officer. And the fact that they claim charge sheet has been filed. Sanction is pending. Question of filing charge sheet, my lord, I beg to, and
And he-
issue for me. And third issue, my lord, that the very document which the Supreme Court prevented being accessed to him are being projected and threatened. And by this court, before this court, they suppress the Supreme Court order and then produce the earlier order and claims that by virtue of Supreme Court order, I got this document.
You have produced the Supreme Court order?
Yes.
Yes.
And he flashes those documents before the media.
My
And
lord,
says that this is what I have got. What is
Lord,
there in the charge sheet and those kind
The
of-
very Supreme Court, my lord, is prevented. He knowing very well
You
that
have placed those orders of the Supreme.
Venkatesh Sabati has placed it, my lord, and I'll also place it.
one submission, my lord, that while addressing press conference, my lord, he shows, my lord, he took one file and shows the entire case of this investigation record is like this. My lord, what was contained in that? They don't have that. My lord, the petition copy and the annexures, my lord, which is relied, my lord, in the Supreme Court, that he was holding it and showing that I know what case it is against me.
You can't take that
No, that is
contention.
what his words is. My lord, kindly, that pen drive, my lord, that the conversation, he was addressing to the press conference, his conversation, my lord, we will place on record, my lord, the 2 pen drives are there. If it is, my lord, heard, my lord, it can be seen that, my lord, it is both in audio and video forum, my lord, it can be
But I
put,
don't
my lord, in the.
There are pleadings in the
system.
petition saying that I have accessed this document by virtue of Supreme Court order. Now I don't understand how they
No,
say.
no, we are not saying that all your investigation records
Pleadings
is with
itself
us.
says, my lord, and I don't.
Whatever the
what
document
happened
given to us, it is with us, not the investigation records. No one said like that.
And it is not just the registration of FIR, not is the basis for the cancellation of bail. There are 6 main grounds.
No, that is not the ground here. That is not the
24th
ground.
you can argue.
My lord,
24th you can argue the matter.
my lord, instead of 24th, either 25th or 27th. My lord,
No, I
24th
have-
and 26th, my specially posted matters are there.
No, I have fixed your MP MLA matters on Monday.
My lord, 24th, my lord, already it is, my lord, in
Can you
portal
come on the
19.
next 7th? Is the next working. 31st is not a working.
But I only request not some accommodation within any of the weekdays, 2:30 PM, Lord. It may not take much time. My arguments only, I will not exceed, Lord, beyond 5 minutes, Lord. If only on the case of
Right, we'll take it on 28.
this, yes, no, 28.
28 is okay with you, Mr. C?
Yes, yes, my lord. It's 28 is.
All right. 28.
Not with the understanding that that's all I request.
No, I am ready
2:30.
now. I am not seeking time, my lord.
2:30,
I
my
am ready
lord,
to argue even now.
That's it, sir. I will-
2:30, my lord, 28.
You can come on 2:30. I'm not giving a date as 2:30.
Very
You
well.
can address at 2:30.
Very well.
28.
Oblige.
28.
Great.
All this matter on 28. Learned Senior Counsel Sri Hasmat Pasha, representing Sri Karyappa, on behalf of petitioner is present. Learned Counsel Sri Venkatesh Arbatti for R3, for post R3. Learned Additional SPP for R1, along with the Learned Counsel for R2 are present. This matter on 28.
Interim order to continue.
Interim order is extended till next date of hearing.
Oblige.
Four. Got it. Got it.
For the petitioner.
What is this non-filing of report by counsel for parties?
Initially, Lordship has suggested, my lord, parties settle the matter and file a joint memo. That did not happen.
There is Vishnu. Yes.
The request now is, there's a spring break coming up for the child, my lord, from 27th of March until the 7th of April. Lordship's permission, my lord, might place the memo on the school calendar. We're only requesting not 50% of that time, because the father, my lord, the grandparents have a house in Kunur. They want to take the child to Bandipur and then to Kunur.
Now the vacation has already commenced.
These schools, my lord, the child is in an IB curriculum. Therefore, their vacations are only middle of May. They have a spring break, not they follow the international.
Which school are they going to now?
But right, 3-year-old child, preschool, Neve. Neve. Document number 2, page number 3. Is the vacation calendar. March 2025.
Document number?
2, not page number 3. But March 28th is the last working day. 29th is a Saturday, and then from 30th onwards, vacation.
I'm not finding where you're reading.
School calendar, March.
March 25, page 4, page 4. Page 4, what does it say?
28th is the last working day of school, not before the spring break. 29th is Saturday, it's a holiday. 30th, 31st, 1st, 2nd, 3rd, 4th, 5th, and 6th. Spring break.
Spring break.
They will include it Saturday and Sunday.
Yes, what happened?
Different case in a different court hall.
Let me call it out later. Let him come. You give a copy of that memo to 2:30. You tell him to come at 2:30, madam. Indra Dhanush. Narendra Babu.
Present, ma'am.
Yes, what is this?
For petitioner in this case, ma'am. My lord, I have challenged the order passed by learned trial court at direction. On the previous occasion, my lord, this honorable court had heard it in detail.
You are the petitioner?
I am for the petitioner. That is the husband before the honorable trial court.
As a respondent.
Respondent, they are intentionally not appearing, my lord. Even on the previous couple of occasions, they have done the same attitude. The thing over here is that, my lord, the respondent wife has suppressed that she is a working woman and she has procured the order from the honorable trial court. Thereafter, they also go to file an execution petition, my lord, on the said order. I file an RTI before the education department, and I'll get an saying that she is a working woman, that she has been employed under government for as guest lecturer for a certain period of time, my lord. The previous bench, my lord, had ordered them to file an affidavit with respect to that. She, in fact, filed an affidavit accepting that she is a working woman. On that note, my lord, I had produced the citation wherein such women who have been suppressing the court and who have been taking the orders from the honorable court shall not be entitled for any relief. This honorable court had.
What is ordered now?
Now, my lord, now they came up with an undertaking that they will not initiate any execution proceedings and they'll stay on that. That was the only order passed by, that was the undertaking given by them. There is no orders as such till date. So it was to be heard in detail, my lord. If the attitude of on the conduct of the respondent may be seen, my lord, we approached this honorable court on 31/7/2023. Immediately, the counsel was served upon them. The petition was served upon them. Thereafter, my lord, till 2024, until
All
and
right,
unless
the respondent is not here now. There you have an order not to precipitate. Let him come. You are the husband. What's your urgency?
my urgency is that, my lord, petition is of the year 2019.
Maintenance application.
Maintenance application.
Hmm.
It is of the year 2019.
Hmm.
Since 2023, I am before this honorable court. Now we are on 2025, my lord. Till date, they are not cooperating to hear the application. Since because they have suppressed it from the court and they have misguided the court and they have taken up. My colleague can give the synopsis over there, my lord, if I can refer the synopsis. My colleague is before the honorable court.
Where is your colleague?
Please, my lord, just check it. So, my lord, in 2023, I had before
Where
this
is your
honorable court.
colleague, sir?
My lord, there was a synopsis which I wanted to submit, but even otherwise, I can continue with the arguments.
The counsel for the petitioners appears through video conferencing. There is no representation on behalf of respondent. Is this matter next week on date code?
My lord, it may be taken on Friday at least, my lord, please.
Huh?
Friday, my lord, Friday or Thursday, please.
27th. 27th.
My lord, there can also be a note made that there is no representation from the respondent for any occasions, my lord. They have been doing that for avoiding for this
You
honorable.
are not able to hear the order of the court?
Please, my lord.
You are not able to hear the order passed by me?
I could hear that it is adjourned to 27th.
I have said that he is not represented by anyone.
Much of this.
The order passed earlier with regard to not precipitation of the execution proceedings shall continue till further orders.
We have challenged the meeting of 16/11/2024 passed by the District Family Court. We filed an application under section 151 to recall the order dated 23/9/2024 passed by the London Family Court, which is at page number 104. Order is from 104.
That is the respondent.
For the respondent, my lord.
Yes, you are ready.
Yes, my lord.
Yes, sir. What is this matter?
What happened is, the motion may take the order dated 23/9/2024, which runs at page number
101.
101. That's the last paragraph. What the family court does is, it gives a direction to the respondent who is the petitioner before this court to get a court commissioner appointed to record the cross-examination of the PW1. So this order we sought to recall, and that IE came to be discussed.
Read the order.
This order.
Read the order.
In spite of several opportunities, cross-examination of PW1 has not been completed, no ground for adjournment. In view of the approaching Dasara vacation and huge number of cases pending before the court, the respondent is directed to take necessary steps for the appointment of court commissioner to proceed with the further cross-examination of PW1.
Who's the respondent in the family court?
It is me, Lord, the mother.
The husband's petition, that is the father has filed it.
Yes, my lord. Yes, my lord.
Both the convenience of both the parties and consists to avoid protection of the proceedings. So on 26/9/2024, we filed the IE to recall this order, which came to be dismissed on 16/11/2024, which is at page number 104. Thank you, Lord. The operative part is at page number 106.
No, after that 101 order, you filed some application.
Yes, Your Lord. On 26/9/2024, I filed an application under section 151 of CPC to recall the order dated 23/9/2024, which came to be rejected on 16/11/2024. That is the impugn order before this order.
Okay, read that order.
It is at page number 104. Advocate for respondent filed application under section 151 of CPC
in IA number 14, seeking for recall of order dated 23/9/2024, claiming that on the previous date of hearing, her counsel was not keeping well, hence her counsel was not able to proceed to cross-examination of PW1. Hence, direction was issued for the appointment of court commissioner for recording of cross-examination of PW1. Since not having financial stability to pay commissioner fee, hence press for recall of order dated 23/9/2024. Advocate for petitioner filed objection on IA number 14. Heard the argument of learned advocate for petitioner. Respondent failed to address oral argument or to file written argument on IA number 14. Hence, posted for orders on IA number 14. Peruse the record. The record shows that petitioner has been filed the petition under section 7 and 17 of GMW Act. The petitioner got examined himself as PW1 and closed his evidence on 19/11/2022. On the completion of chief examination of PW1 on 19/11/22, case was pending for cross-examination of PW1 till 24/8/2023. In spite of several opportunities, PW1 has not been subjected for cross-examination. Hence, cross-examination of PW1 was taken as read on 24/8/2023. Thereafter, the respondent came up with IA number 12 and 13 for recall of order dated 24 and 23. At the request of the respondent IA number 12 and 13 were allowed on 4/9/2023 with the condition to proceed with the cross-examination of PW1 without seeking adjournment on the scheduled date of hearing. In spite of the specific direction, respondent failed to proceed with cross-examination of PW1 and to conclude the cross-examination. It is often reported to the court that the orders dated 24/4/2023 regarding litigation rights given to the petitioner has not been complied by the respondent. Through the order dated 24/4/2023, the respondent was directed to accommodate the petitioner to have a hearing between 2/5/2023 and 5/2023 before the joint memo dated 19/1/2023 filed reporting the settlement and between them regarding visitation right. Since the terms of joint was not complied, IA number 8 came to be filed. The entire records placed before the court shows the protection of proceeding. The respondent failed to make all the grounds for recall order dated 23/9/2024. Hence, proceed to pause the following. IA number 14 filed by the respondent under section 151 of this is dismissed and the respondent is directed to comply the order dated 23/9/2023 without fail by 23/11/2024. In fact, the PW1 has been cross-examined on 2 exams.
What is the order on 23/9 for compliance?
That was for appointment of court commissioner for recording the cross-examination. That was the direction. The last paragraph.
Court commissioner to proceed with further cross-examination of PW1.
Yes.
So you are to go and cross-examine PW1 through a court commissioner.
Yes, that's what the trial court does it, Lord. The stage was fixed for cross-examination of the PW1. On 2 occasions, we have cross-examined in partly, Lord. So on 2 occasions, the matter was deferred for further cross-examination on the ground that he need to produce some medical documents. What was pointed out during the cross-examination.
What happened to the petitioner?
Petitioner took time to produce this document.
Now, what is the difficulty with the petitioner? Why cross-examination through commissioner?
No, we have not sought for court recording to appoint a court commissioner.
Who was sought?
Court has directly also motive.
Why?
On the ground by saying that since there is a huge number of pendency of the case and the certification and there is a delay on the part of the petitioner. That is the reason. Pen number 1 more.
May I submit, my lord?
Yes. Yeah. That is all your argument.
On the date of 23/9/2024, I file a memo which is wanted to find which is Your Lordship,
This is a child custody petition.
yes, my lord.
Yes, my lord.
Child is how old and with whom?
Child is with the mother, my lord. His age is 12 years.
So you are given a direction to comply and show the child to the father. You are not done.
Yes, yes, my lord. Exactly.
Point is,
Huh?
I have complied those orders.
Interim custody of the child between 2/5/2023 to 18/5/23 is complied.
They did not comply, my lord.
Happened is, child was for vacation, he went to Mysore. And in between this, the.
How old is the child?
12 years, now it is 13 years.
Boy or girl?
Why?
Male child.
So you have complied that 2/5/23. Which is that order?
Brought the child to from Mysore. I handed over to the petitioner, to the petitioner father in the JW. The child was reluctant to go. What is the point of me? My job was to bring, because the child and me has gone for vacation in Mysore, because my native is in Mysore. So since to the tune of the order passed by the London family court, I brought the child. And handed over to the petitioner father. The child was reluctant to go, he was crying, So what was the fault in the mother? And moreover, whenever the London family court has directed to produce the child before the court, I have produced, And it is a part of the order sheet. If your office says, I point out the date wise.
So both of you are residents of Bangalore.
Yes, Your
Yes, my lord.
Presently, we both are the residents of.
All right. That's all.
The reason for why I sought the adjournment on that particular day, I filed a memo. Filed the memo which is a part of this petition, annexure E, which is at page number 53. The council was suffering from UTI, Your Worship. That is the reason she could not be present on that particular day. And this was the adjournment was sought. A memo came, the type copy is at page number 54. And earlier this, the petitioner himself has taken a huge number of days to produce the document before the family court. Which is also a part of the order sheet,
All right.
So there is no intentional delay of the proceeding on the part of this petition before. So therefore, your worship may set aside the order and fix any date or the date which is before the family court. On the same date, will conclude our cross examination without any seeking any adjournment.
All right.
Lord. My lord.
Yes, yes. Yes,
I have, yes, my lord. My lord, I have completed my chief examination on 19/11/2022, my lord. Till now, my lord, it is about 19/11/2022. Till now, it is about 18 months, my lord. 18 months happened. Meanwhile, my lord, subsequently, the advocate for the petitioner, my lord, they have submitted IA number 6, 7, 9, 10, and 12, 13. There were so many opportunity has been given, my lord. The trial court has imposed so many times heavy cost and allowed the applications, but still, my lord.
Where is that?
Yes, my lord. Lord, it's in page number 77, my lord.
Yes, read it.
Yes, my lord.
So when did the cross-examination of PW1 begin?
Let's
Started on.
1 minute. Your argument is over. Let him argue.
Look, my lord, it is started on 4/9/2023, my lord. 4/9/2023. It's in the 77 only.
4/9.
2023, my lord.
The reopening, recall, cross-examination.
Yes, my lord. Lord, they filed recall and reopen application. When the matter is listed, my lord, it has gone for the judgment. By that time, they came to the record and they filed recall and reopen application. From that time, my lord, subsequently, they have filed 4 to 5 applications. Till today, all the applications were allowed on heavy cost, my lord. My point is, my lord, I have no objections to the allow this application. But thing is, my lord, from the day one, my lord, they are not showing the kid. Several times they brought the child to the court hall, my lord. The
Where
thing
is the
is,
order of that visitation rights?
yes, my lord. That is on 11/4/2023, my lord. It is allowed, my lord.
11?
11/4/2023, my lord. 2023, my lord.
Page.
I think they have not furnished that.
All right, if they have not complied with the visitation rights order, you go
Yes,
and
ma'am.
execute it, file contempt. We'll
Yes, ma'am.
allow this, give a direction to him to complete the evidence.
And
trial
also, my
court.
lord, they only approached us to file a joint memo. That also not complied.
For what?
For the visitation rights to the child, my lord. That also not complied by the petitioner.
Hmm.
From the 18 months, my lord, none of the other reason, my lord, they just drag the proceedings.
Is
Now
there
they
any
asking for
other
the.
petition other than this custody petition? Any other petition?
Yes, it is all disposed, my lord. I have filed RCR MC case before the family court that was allowed in favor of me, but not executed by the petitioner. And also, my lord, the petitioner has filed divorce MC case before the Mysore court, MC number 448 of 2019, that is dismissed. We wanted to see the child, my lord, then never given opportunity to child for the interim custody and also visitation of child, my lord.
All right.
I'm bearing the all expenses of the school. And if I am go to the school to meet the child and pay the fees, they go to police station and give the police complaint. And they submit photographs and all before the trial court. This is all happening, my lord.
All right,
Kindly
I'll pass orders in the
direct
afternoon.
Yes, ma'am.
I'll pass orders in the afternoon.
Much obliged.
Yes. Yes.
So this 3 serial number 14. The other side counsel is also here, my lord. So
They are here.
yes, please.
You should have mentioned earlier, what were you doing all this while?
I'll come at 2:30.
The parties are from where?
Parties are from Hospet, my lord. Petitioner is from Hospet. She's here. She is also here.
Parties are from hospital. Both of them are here.
Please, both of petitioner is also.
All right. Joint memo is filed.
Please.
Good. You served. You signed. Both of you have signed.
Already signed.
All right. We'll take it up at 2:30 first.
Please.
List number 3, serial number 16, my lord. Going with settlement, my lord. We have a petition.
List number
3, serial number 16, my lord. 3.
serial number
16, 16, my lord. 16. Pick any date, my lord, to file compromise petition.
adjourn ಆಗಿದೆ.
It was, understanding was the matter was to be heard.
15.
But then 58, and there was a direction, your lordship said that to get the records by telephonically. Madam, records, something like that.
I'll hear you. Okay.
Last time also is taken on the same ground that he was not well. My application is one.
ಒಂದು ನಿಮಿಷ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ. ಕೇಳೋಣ.
Sorry.
You are claimant, is it?
No, I am claimant. He
Who
is
are
the
you?
Owner of the vehicle.
All right. You have filed for withdrawal.
No, no, I am for the claimant, my lord, that he has no driving license insurance, that he made liable to this one, MACT.
All right, ಒಂದ್ ದಿನ ಎರಡು ದಿನ ಟೈಮ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ? Is not well today. We'll have it day after tomorrow.
Not there.
Huh? Huh.
Next Mangalore, that is 25th Mangalore.
26.
26th.
All right. At request of learned counsel for the appellant, list this matter on 26th, which is opposed by learned counsel for the respondent. Counsel for appellant submits, he would positively argue the matter on 26th.
Please note, records.
To IA.
Madam, records is not.
ಅದು ಬೇಕಾಗಿಲ್ಲ ಮೈನ್ ಮ್ಯಾಟರ್ ಡಿಸೈಡ್ ಮಾಡೋಣ.
Records last time ಹೇಳಿದ records lordship.
ಎಲ್ಲಿಂದ ಬರಬೇಕು?
Udibandi.
Registry director secure the records through ಬಂದಿದೆಯಾ? See available.
Please.
Yes, madam.
19, may I request the lordship to take it up at 2:30 because twice it was passed over. He's come from Pune.
Bandidara party.
Yes, my party is here. He's come from.
Were they asked to be present? Other side is not here.
He was here.
Take it up at 2:30. 2:30?
Madam. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ನಾನು ಶರ್ಮಾ. ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ 38 ಏನೋ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಿದಾರ?
ಸರ್ ಲಿಸ್ಟ್ 3 ಎಲ್ಲ ಅರ್ಜನ್ ಆಗಿದೆ ಸರ್.
ಎಲ್ಲ ಚೆನ್ನಾಗಿದೆಯಾ? 38 ನೋಡಿ ಸೀರಿಯಲ್ ನಂಬರ್.
ಹೌದು ಸರ್ ಅರ್ಜನ್ ಆಗಿದೆ ಸರ್.
ಸ್ವಲ್ಪ ನೋಡಿ ಹೇಳ್ತೀರಾ?
ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಏನೋ ಹೇಳಿದಾರೆ ಸರ್ ಡೇಟ್.
38, 38.1 ಅಂತ ಎರಡಿದೆ.
ಹೌದು ಸರ್ ಹೌದು.
ಎಜರ್ನ್ ಆಗಿದೆ ಅಲ್ಲ?
ಅರ್ಜನ್ ಆಗಿದೆ ಸರ್.
ಓಕೆ, ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್.
ಹಾ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಸಾರಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದೆ.
ಇಟ್ಸ್ ಓಕೆ ಸರ್, ಇಟ್ಸ್ ಓಕೆ.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, there is an execution that is issued. They have taken an attachment
I
for.
hear you.
There is an execution that is moved and appealed by the insurance company, Milas. They have taken an attachment for tomorrow, Milas. Freshman. Obliged.
Compromise, huh?
Fine.
Huh?
Yeah, file a joint memo.
Huh.
Shall obtain for certain terms for settlement.
Huh.
File a joint
All right. Yes. Yes, madam, what is your name? Akshata. You're comfortable in English? English ಮಾತಾಡ್ತೀರಾ ಕನ್ನಡ is better. Okay, ಮುಂದೆ ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ. Turn the mic towards her. All right, you have agreed for some settlement?
Yes, sir.
Your husband?
Yes,
What is the settlement agreed?
sir. ನಾನು ಪರ್ಮನೆಂಟ್ ಗಾರ್ಡಿಯನ್ ಅಂಡ್ ಕಸ್ಟಡಿಯನ್ ಆಗಿರ್ತೀನಿ ಮಗುಗೆ ಅಂಡ್ 25 lakhs ಕೊಡ್ತೀನಿ ಅಂತ ಕೊಂಡಿದ್ದಾರೆ. ಅದು ಮೇಂಟೆನೆನ್ಸ್ ಆಫ್ ಬೋತ್ ನಂದು ಮತ್ ಮಗುದು ಮತ್ತೆ ಎಜುಕೇಶನ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಮಗುದು ಮತ್ತೆ ಎವ್ರಿ ಮಂತ್ ಲಾಸ್ಟ್ ಸಂಡೇ ವಿಸಿಟೇಷನ್ ರೈಟ್ಸ್ ಇದೆ 9 to 6 ಹಾಸ್ಪಿಟಲ್ ಸರ್. ಆಮೇಲೆ ಅವರು ಮಂಗಳಸೂತ್ರ ಕೇಳಿದ್ದಾರೆ, ಸೊ ಅದು ನಾನು ಕೊಡಕ್ ಅಗ್ರಿ.
And ನಿಮ್ದು any other articles of yours?
ನೋ ಸರ್.
What about the cases filed?
ಯಾ ಸರ್, ಅದನ್ನ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂತೀನಿ ಸರ್.
Which are those cases?
ಇಸ್ ಅಬೌಟ್ ಹರಾಸ್ಮೆಂಟ್ ಕೇಸ್ ಇದೆ ಸರ್, ಕ್ರಿಮಿನಲ್ ಕೇಸು ಮತ್ತೆ
And you will open one PPF account also?
ಎಸ್ ಸರ್. ಇನ್
ನಿಮ್ಮ
ಕಮಿಂಗ್
ಪಕ್ಷ-
ಡೇಸ್ ಲೈಕ್ ನನ್ಗೆ ಜಾಬ್ ಸಿಕ್ಕಾಗೆ, ಈಗ ಸದ್ಯಕ್ಕೆ ನಾನು ಅನ್ಎಂಪ್ಲಾಯ್ಡ್, ಮುಂದೆ ಜಾಬ್ ಸಿಕ್ಕಾಗೆ ನಾನು ಮಗುಗೆ ಓಪನ್ ಮಾಡ್ತೀನಿ ಸರ್ PPF.
All right. ನಿಮ್ಗೆ ಯಾರು ಇದು ಒತ್ತಾಯ ಮಾಡಿದಾರಾ, ಫೋರ್ಸ್
ಇಲ್ಲ
ಮಾಡಿದಾರಾ?
ಸರ್, ಇಟ್ಸ್ ಮೈ
Voluntarily agreed?
ಎಸ್ ಸರ್, ವಾಲಂಟರಿ ಅಗ್ರಿ.
Nobody is forced you?
ನೋ ಸರ್, ನೋ
You are satisfied with the settlement?
ಎಸ್ ಎಸ್.
Yes, what do you say?
Sir, I'm
Yeah.
sorry.
ನೀವು agreeable settlement?
Yes, I agree.
ಎಷ್ಟು amount ನೀವು ಕೊಡೋದಿದೆ?
25 lakhs.
ಯಾವಾಗ, how you are going to pay that amount? ಎಷ್ಟು?
I'm paying in installment.
ಎಷ್ಟು?
10 lakhs if she removes one case, and 10 lakhs and then 5 lakhs.
All right. And you will continue to pay for the child?
Yes, I will continue.
But in the joint memo, you have extracted the same thing as the settlement agreement.
Same. After was referred to mediation results, then we have entered in this.
So MC petition is filed by whom?
The respondent has.
Husband. But learned counsel for the petitioner and learned counsel for the respondent. Parties to the proceedings, namely Srimati Akshata Kattimani and Sri Shreyas Samraksh, are present before the court physically. The present petition came to be filed by the wife seeking transfer of the petition from the Principal Judge Family Court Bengaluru to the Principal Civil Judge JMFC Hospital. During the pendency of this petition, the matter was referred to the Karnataka Mediation Center Bengaluru for making an effort to resolve the dispute amicably. On the parties approaching the Karnataka Mediation Center, at the instance of the parties themselves and well-wishers, the parties have amicably settled that matter. And in order to put an end to the matrimonial discord and ordeal, they have entered into a memorandum of settlement. Under section 89, the Code of Civil Procedure 1908, read with rules 24 and 25. The Karnataka Civil Rules Procedure within brackets mediation rules 2005. both the parties have agreed to the terms and conditions as stipulated in the memorandum of settlement agreed for the Karnataka Mediation Center. The terms and conditions have been enumerated in the settlement agreement. The parties are physically present before this court. This court has inquired with both the parties, that is the petitioner, Srimati Akshata Kattimani, and respondent, Shri Shreyas Samraksh. They submit that they have voluntarily entered into the settlement of agreement, put an end to the matrimonial discord, and also made arrangement for the welfare and well-being of the minor child, including visitation and maintenance, and that of the petitioner wife. There are certain cases pending against each of the parties. They submit that in accordance to the memorandum of agreement and settlement, they will withdraw the cases, bar compound the offences, and file the necessary petitions for resolving the marriage between the parties, between themselves. That MC case is 5100 is pending. Therefore, in view of the settlement agreement entered into by the parties in the mediation, Karnataka Mediation Center, parties seek a disposal of this petition to settle the dispute amongst them in the concerned courts by following the terms and conditions stipulated in this memorandum of settlement. Full stop. Para. Both the parties submit that they have voluntarily signed this agreement without any force, coercion, undue influence, or pressure. They have affixed their signature on their own free will and consent without any coercion, and that they would abide by the terms and conditions stipulated in the agreement. Full stop. Next paragraph. In view of the settlement agreed into between the parties before the Karnataka Mediation Center to put an end to the litigation, this petition requires to be disposed of by a direction to the concerned courts upon the parties filing necessary petition for closure, namely for dissolution of marriage in the divorce petition, for withdrawal of the necessary petitions filed by the wife, and for compounding of the offences initiated against the respondent husband. Only you or others also are there in, along with him, others are there?
Parents.
And others along with the respondent husband. Petitions shall be compounded and closed in accordance to the terms and conditions of this settlement agreement. So also the respondent husband shall make the payment of amount as agreed to in these petitions, in the memorandum of settlement agreement. Full stop. Full stop. In view of the above, this petition is disposed of as settled, and the parties to comply with the terms and conditions as per the memorandum of settlement. The memorandum of settlement and the joint memo of settlement shall form part of this order. Sign ಮಾಡಿ. One more. ಇನ್ನೊಂದು ಯಾವ್ದು ಸೆಟಲ್ಮೆಂಟ್ ಅದು ಇಲ್ಲ. Oh, that was adjourned. Yes. Not here.
Plus, this is the jurisdiction issue. I know he's not there again.
Morning he has not been appearing.
Yes, I'm also, this is the third time that is being called.
Appear for the petition, respondent, my lords.
Sorry, not appearing in this matter.
No, I morning by the time I reached, sorry, my lord, I could not. Lordship, may kindly see in this matter, there are many, the suppression of facts in this case, there is the reason why I want to place on record certain documents and materials, my lord. That's the reason why I seek some time to file my object statement of detail. Reason is, Lordship may kindly see, similar set of facts by suppressing before this honorable court, they approached the Pune court on the same day, same set of facts. This was been stayed by Honorable Supreme Court on the same relief. Now the matter is stayed by Supreme Court. Now they're showing such an urgency before this Honorable Court, stating that matter is in grave urgency. Fact is that Lordship may kindly see this. She was been thrown out of the matrimonial house almost a year back. I filed a petition for a GNWC petition before this Honorable Court, before the.
Where is the order of the Supreme Court?
Supreme Court, I will also place it, my lord. That is the reason why Lordship may kindly see. There's a reason last week it has happened. I want to place all those things on record, my lords. That is the reason why I need some time to file a detailed objection in respect of that.
Grant you file it next week.
Next week, my lord.
So on the same grounds, he sought time last time and time was given to file the objections and place
No,
on
no, no, no.
record.
This is how
However,
the my lordship
nothing,
may kindly.
let me
Sorry.
also speak. However, nothing has been placed
False
on
submissions are
record.
made.
In fact, suppression is not by me, my lords. It is by him. That before Supreme Court, they filed a transfer petition seeking to transfer the petition filed by the father before the Pune court. That whatever has transpired in Bangalore court, they filing the petition, or that for that matter, the writ petition being pending, there is an order of interim stay granted by this court. Nothing is there in the transfer petition that is there before me. I can produce it with the memo. They took time to file this, my lords, before this date. In fact, today was the date given for them to place before the court.
No,
Nothing has been
absolutely long,
placed
my
on
lord. This is
record.
what exactly
In
short
fact,
make. Sorry,
suppression
my
is by
lord.
them. I'm unable to understand why.
Mr. Counsel.
Please, my lord, a week's time, my lord. I shall place all the thing on record, my lord. My learned bed making a bar on false submissions. It is not on the ground. She sought for a ground. She sought a time for placing because the mediation is failed. Therefore, she asked for it. It is not. It is nothing on nothing. I am not made any submission in respect of stating that placing a record. This is a false submissions. Unfortunately, this is exactly.
I list this matter on
At
Friday.
least 10 days, my lord. Maybe for following week, my lord. I have to get these documents from the Supreme Court also. That is the reason difficulty. Certified copy is another document which is filed before the apex court. I want to place it before this honorable court on record. What they're asking is same thing. 10 days time I'm seeking, my lord. And the meantime I'll file.
In fact, the date I sought today was because the child's exam is going to commence from 24th. That is the difficulty in Pune, which admission is proper. However, the mother has brought the child and provisionally got her admitted to some school in Bangalore, which is not even a proper admission. So the child has to attend the examination that is there.
I have not even attended the classes. Where's the question?
Plus, the school is permitted. In fact, I have the.
How old is the child?
Child is 10 years. In fact, I have.
Which class? Which class?
5th standard, the timetable and the school that is sent an email to the father. All that is there, in fact. The school has sent that the child can attend the exam.
When is the exam?
Plus 24 minutes. Timetable has come.
24th now. How the child is going?
That is the reason today I had sought, because of this very reason. It's not that I have any objection for him to take time. Otherwise, there was no difficulty.
Where is the child now studying, Mr. CG?
He is studying in Bangalore, my lord. This lordship may kindly see. Let them not make use of child as a tool for their legal battle, my lord. That is my full submission. They will very well know that 1 year they sleep over the matter, do not do anything. After almost 1 year, they come back and making an urgency stating that child has to write exam. What was he doing all this while? He didn't even approach the family court in Pune. If at all you had something, after filing a petition, matter has been stayed by Honorable Court. Things are not working according to his taste. Now he realized that no, some petition need to be filed in Pune and there is an urgency. Lordship, these are the things I want to place on record, my lord. That shows their
Produce
how
those
clean
documents,
court-
I'll give you a week's time.
Plus, in
Otherwise, this
fact-
court will proceed further if you are unable to produce.
Plus Pune court, he has sought for permission for the child to appear for the exam. It is that they have sought stay and brought a stay. And I have not suppressed anything. It is they who have suppressed
What
all
is the
along.
order now passed with the Supreme Court in the
Plus,
transfer?
Supreme Court has stayed the proceedings in the Pune court, before the Pune court.
That will not proceed.
Same
now.
prayer.
Yes, correct. So the
Correct.
only option is before your lordship, my lords. I think they also know that. And since this is a provisional admission that the mother has sought, it's not as if the mother can travel all over India and take the child along with her and keep asking the father to sign the consent form. That is not the right procedure. All along, the father has paid the fees from the time of birth, and child has stayed in Pune, studying in Pune, excelled in all the studies in Pune, and wishes to go to the school in Pune, which he has expressed during the visitation.
She is in which class now?
5th standard, my lords, 10 years. I produced all, in fact, the academic records of her marks card and everything, my lords.
Girl child.
Girl child.
Oh, what good.
I produced the photographs wherein she is extremely close to the father as well as the mother.
Learned counsel for the petitioner is present along with the petitioner. Learned counsel for the respondent seeks time further, intending that the Honorable Supreme Court has granted the stay of the proceedings initiated by the father in the court at Pune. He seeks time to produce the said order and file objections to the present petition. Providing one last opportunity to the respondent. Call this matter on next week.
Plus 24th is the
Monday
exam.
ago, sir.
I
Monday
request-
ago.
The exam now.
Plus at least on Friday, because they were supposed to place it today, my lords.
No, you can't now ask the child to attend to the exam. How? Physically or
Plus,
VC?
even online, it's all right. They're permitting her to appear online. Plus, what is,
That is
what,
putting
Not
too much of
Friday, madam.
pressure on the child now.
my difficulty
See,
is,
now the
lords,
child is studying in Pune, according to you. According to you.
the admission is a proper one, which is
Now he must have put the child here in some school.
correct, some school here. Yes,
Now what happens to the mental psyche of the child?
that's exactly what I'm also saying, my lord.
That has to be decided now, whether the child doesn't attend. will
Your
not
lordship will have to decide.
take, But now it is not going to matter much whether she's going to take up the exam in Pune or Bangalore. If this
But
court decides
exam-
otherwise, in your
Because
favor.
rightly, this court, Bangalore court does not have jurisdiction to decide the custody
That will
petition
has to
that
be
is.
decided, that has to be
Correct. That's
decided.
exactly what I'm saying, because the child is ordinarily residing in Pune. Plus, I think Friday would have been an appropriate date considering that,
Next Monday,
At
my
least-
lord.
because
Friday,
they
some-
sought the time today. It is not as if, they had not
No,
sought,
no,
my
no,
lords.
you-
That's the only.
They asked for a
thing.
time, my lord, not I. She wanted urgency.
I
that's
did
what-
not seek any
I
time.
asked for 2 weeks, my lord, last time itself, because my difficulty is that I did not get this document.
Already you filed by the 27th,
Next Monday, my lord, not following Monday, my lord.
huh?
Follow-
24th. You want on 24th? All right.
Not 24th, my lord. 10 days time, my lords.
No, 27th you file it, otherwise I'm passing orders on that.
Please, my 27th.
27th.
So what happens to the child and the
Nothing
exam?
will happen,
not
madam.
unable to- Because she can't appear even in Bangalore, as per what because the admission process is not
My
complete.
lord, the examination
It's
is
only a
already-
provisional
child is
admission.
writing
So
the
at least let her
examination in
appear
Bangalore.
online or whatever and complete that so that later on, if the matters get settled, then there can be a
This is
proper
a
admission.
final exam.
Final exam, yes.
Final exam, already
It's
she's
there,
writing in
my lords. I
my
can
Bangalore.
file it with the memo.
She's
It's
already
there.
All
writing
that,
the
madam, is
exam.
a question of now dispute. All this is a question of dispute which has to be thrashed out by the court while
Correct.
passing an order.
No doubt, but
So now we're asking the child to take up the exam in Pune and again in Bangalore is taxing too much for the child.
plus Bangalore, the admission process itself is not correct.
May not be correct, but what is correct or not correct, this court
Because-
will decide.
No,
doubt
why
about
I'm
it.
saying that is transfer certificate has not been given.
That we'll
that is the reason.
consider. Consider, we'll give a direction to the court if.
At
she-
least for this year, my lords, for the 5th standard, which the child has been admitted to Pune, I think I can only pray that the child be permitted at least online to
What is the
appear.
difficulty for the child to attend to that exam tomorrow if this court was to decide against you?
No, my lordship, because already the child was studying throughout it. These are all last minute, they're putting
No,
a
no.
pressure.
Suppose if
on
this
my
court
lord.
were to decide against you,
Please, my lord.
what happens to the child's future?
Lordship, because she's writing, already started writing exams, my lord, here in Bangalore. The
Which
school
exam
which
she's
she
writing,
studied
please?
through the entire year.
Huh?
Final exam she's attending here in Bangalore, already she's taken up
When
the
did she
exam.
join? When did she join?
Last academic year itself, my lord, April itself, she's joined in Bangalore.
2024 April.
That is the reason why Lordship may kindly see 1 year they sleep over the matter. They don't
Please
do
tell me
anything.
the date, sir. Please tell me the date.
24th of, she was thrown out of the house on 24th April 2024, my lords. Thereafter, she joined the Bangalore school in May.
Where? Which school?
Bangalore, Vibjor school in Bangalore. It's one of the reputed school in Bangalore.
For which class?
Fifth standard, my lords.
All right. She's now taking up the final exam when?
Yes.
When?
No, already examination already is commenced. Practical examination already stage is given. 24th onwards, her regular examinations going on.
All right. You file your statement and.
Statement of objection. I place all the records, my lord. That is the reason. That is the reason why I'm just taking time and all that. Sorry, my lord, for.
Let's let it be posted on 24th.
You should place all this. You are now playing with the child's life and career.
Yes.
Because of your own whims and fancies of the mother trying to take the child and
I
come
will
away.
no, my lord, the reason for bringing her to, she has been physical.
Whatever may be the reason. Whatever may be the reason.
For the purpose of safety, she left the house. One side is saying that he wants to take care of, another side
Have
is
you
a brutal.
taken the transfer certificate from Pune?
He is not giving, my lord. School is ready to give. Provided he is giving a consent. Even the order was passed by the family court Bangalore. That which they don't even challenge that order. To overcome from that order, to contempt proceedings, they realize that is going to be initiated against them. That is the reason why immediately this present petition was filed.
Right.
This is the intention. These are all the records I want to praise before the Honorable Court in respect of their contact.
27.
Plus 20.
Much obliged,
I
madam.
request on 24th.
Not possible.
Because he was ready for 24th earlier.
No. See, this is what 27 they are asking. I was asking following week.
Because I think 24th would have been the right thing. Either this way or that way, whatever, it is a matter of child's education, that is all.
Oh,
Because
writing
if
the
it is not-
examination in Pune is ruled out because he's already here.
because
for the
even
past
there is an option, even online, the child
academic
can
year
attend.
she's here. If she succeeds here, she'll move to the next class. You can go back to Pune if you are successful.
What if this petition were to go back to Pune, my lords? Because this is not the right jurisdiction. In that case.
What I'm
the
telling
child-
you, if you are all able to succeed. And
Because
this
either
is
which way, there is no harm in the child writing the exam.
why you should put the child. I don't understand, madam.
No, I'm just saying the admission.
No, the child is already here for one academic year in the jurisdiction of Bangalore.
Correct.
She's
That's what they are
taking up the
submitting.
5th standard exam.
Yes.
She passes this exam, she will go to the next class to Pune if your petition is going to be accepted. What's the difficulty? Whether she writes the exam, doesn't write, makes no sense.
I leave it to your lordship because admission is already the
Maybe
proper one in the
your
Pune.
concern is that the exam she will miss. She's already writing the same 5th standard exam here
That's
final.
just oral submission. We don't even know whether there is a exam.
All right, we will
whatever
see.
this-
We'll make some arrangement for that.
I will praise all the records before this Honorable Court, madam.
All right, I leave it to your lordship.
Petitioner. Yes.
My lord, I've received certain document. He has filed it along with the memo. We check it out and I'll file my reply to that, my lord.
Sorry, you're not audible. Take the mic.
My lord, I have received a memo, my lord, along with certain documents. Short accommodation would be well, madam. I can file my reply to this, my lord.
School calendar. Both the parents have it.
What is it now you're seeking by virtue of this?
Lord, the child's vacations, my lord, spring break commences on 28th is the last working day, next Friday. She has about 10 days holidays. I'm requesting, Lord, I mentioned that the paternal grandparents have a house in Kunur. So the father and the grandparents, my lord, and the entire family wants to travel to Kunur, my lord, for 4 or 5 days with the child. They go to Bandipur and Kunur. That is the plan they have. 10 days holidays there are.
Right, but where is your application?
No, the writ petition is for sharing 50% of all vacations. That is the entire prayer in the writ petition is that. The interim prayer also is that.
Is it anything is granted or yet to be granted?
But the family court, my lord, did not consider my request for sharing of vacations. I was given visitation only Monday to Friday. Your lordships have subsequently modified the order where even on Saturday I pick up the child and drop the child back on Sunday.
That is only for the weekend.
Weekends. For vacations, no arrangements have been made. And therefore, my lord, this request.
So this application was rejected?
The application, my lord, my application was partly allowed. It was one comprehensive application for visitation, vacations, birthdays. There's a comprehensive application filed before the family court.
So that was partly allowed and you were only given the video call and
visitation Monday to Friday.
Yes, Mr. Counsel, you want, what is your?
My lord, my humble submission, kindly accommodate me some time, my lord, so that I will look into these documents, whether the vacation should be provided or not.
We'll have it next week, Monday.
Please, sir.
Then counsel for the petitioner has filed a memo along with 2 documents, copies of which are handed over to the learned counsel for respondent. You are appearing for Vishnu Hegde?
Yes, my lord.
All right. Copy is received by the learned counsel for respondent. List this matter on 25th.
Please, my lord.
Make your submission, go through that, make your submissions.
Oblige.
Please, oblige. Much obliged.
ಯಾವುದು? Where is your friend?
He appeared through VCV, lord.
So the respondent below.
Yes.
Impugned order is at page number 104.
Is this petition is filed by the wife against the respondent husband. Full stop. Challenging the impugned order dated 16/11/24, passed by the third additional principal judge family court at Bengaluru in G and WC number 31 of 22 on IE number 14. Consequently seeking to allow the IE number 14 and permit the petitioner herein to cross-examine the respondent. Full stop. Paragraph. The respondent father had filed a petition for custody and guardianship of the minor child, namely Master Rushank S. Yajman, who was aged 9 years then, before the Principal Judge Family Court at Bengaluru in GNWC number 31 of 2022. In the said custody petition, when the evidence of the father had got concluded and the mother had partly cross-examined the father of the minor child, an application came to be filed seeking adjournment on 23/9/2024. Which was not accepted. However, the learned family court judge, is it family court?
Third additional
Family court judge directed the respondent mother therein to take necessary steps for appointment of court commissioner to proceed further for cross-examination of EW1. In view of approaching Dasara vacations and huge number of cases pending before the court, and despite several opportunities, the respondent therein had not utilized the same, the matter was adjourned to that effect. Subsequent thereto, the mother had filed an application, IA number 14, seeking to recall the order dated 23/9/24 and permit her to cross-examine PW1, that is the father, on the ground that on 23/9/2024, due to the ill health of the counsel, the mother could not cross-examine the father in the said custody petition. This application filed under section 151 of CPC, numbered as IA number 14, came to be rejected by the learned judge of the family court, which is questioned before this court. Full stop. Next, new paragraph. It is the contention of learned counsel for the petitioner herein, who was the respondent petitioner herein, who is the mother, that on an application filed on 23/9/24 seeking adjournment, the same was rejected, and the learned judge of the family court directed the petitioner herein to take steps for appointment of court commissioner to cross-examine PW1, as despite several opportunities, the same was not utilized, and the ensuing Dasara vacations and huge number of cases pending, it would not be possible to accommodate the petitioner to allow the application or cross-examine PW1. The matter was adjourned thereafter to 26/9/2024. Full stop. The petitioner herein filed an IE number 14 on the said date, seeking to recall the previous date order of 23/9/24 and permit the petitioner herein to cross-examine the husband by providing an opportunity, as she was unable to cross-examine PW1 due to her counsel being unwell, and she has filed a memo to that effect before this court. Full stop. It is further contended by learned counsel for the petitioner herein that if the application were to be allowed, no hardship or inconvenience would be caused to the respondent herein. On the contrary, it would be better for the petitioner to cross-examine PW1 physically in the open court rather than taking the help of a court commissioner to cross-examine the witness. For the reason that it is neither the case of the petitioner nor that of the respondent to cross-examine PW1 through court commissioner. Full stop. It is also contended by learned counsel for the petitioner that he would go on with the cross-examination of PW1 without causing any further delay and in an expeditious manner. Full stop. Accordingly, he seeks to allow the petition. New paragraph. Per contra, learned counsel representing the respondent husband, who is PW1 in the custody petition, contends that several opportunities were granted to the petitioner herein to cross-examine PW1. It is submitted that on 19/11/2022, PW1 had completed his examination in chief and the matter was posted for cross-examination. And from then on, the petitioner herein has been taking time by partly cross-examining and thereafter prolonging and protracting the matter for one reason or the other. Under the circumstances, he contends that the family court, in fact, had imposed cost against the petitioner herein for unnecessary protraction of the proceedings. Full stop. On these grounds, he submits that the petitioner herein is deliberately trying to protract the proceedings with an intention to cause delay, and also has violated the orders of the family court in parting with the visitation rights as provided by the family court, which is blatantly disobeyed by the petitioner herein. On these grounds, he seeks dismissal of this petition. Full stop, new paragraph. I have heard learned counsel for the petitioner and learned counsel for the respondent. The point for consideration before this court is whether the petitioner herein should be permitted to cross-examine PW1 by recalling the order dated 23/9/2024 by providing an opportunity of completing the cross-examination of PW1. Full stop. It is borne from the records that the evidence of PW1 is completed on 19/11/22. The petitioner herein had cross-examined PW1 partly and thereafter has taken time to cross-examine and despite providing several opportunities and costs being imposed twice, cross-examination of PW1 is not completed. Therefore, the learned family judge rejected the application filed by the petitioner under IA number 14 to recall the order dated 23/9/24. Full stop. I will peruse the impugned order and the order sheet of the family court. It is true that despite granting several opportunities, the petitioner herein has been protracting the proceedings. Though there may be certain valid reasons for the counsels to appear, which are stated in the application and in this petition. Nevertheless, the custody petition is of the year 2022. Evidence of PW1 is completed on 19/11/22. But the cross-examination is not completed despite several opportunities being granted and costs being imposed. Under the circumstances, in order to provide one more opportunity to the petitioner herein, the mother, this court deems it appropriate to allow this petition the petitioner mother shall be permitted opportunity to cross-examine PW1 by the learned judge of the family court. We'll stop. Next point, next paragraph. The petitioner is permitted to cross-examine PW1 without protracting the proceedings, and the cross-examination shall be completed in two hearing dates. Two hearing dates.
Well, also already Yes, my lord. Only one date may be opportunity given, my lord, because they
Two
have
hearing
completed
dates,
everything.
which shall be fixed by the learned judge of the family court. Full stop. Next paragraph. It is made clear that if the petitioner does not cross-examine PW1 on the date fixed by the family court, the cross-examination shall be taken as nil, and the family court would be at liberty to proceed further in the matter in accordance with law. Full stop. New paragraph. This order is passed subject to the petitioner paying cost of ₹5,000 to the respondent herein, which shall be paid before the family court prior to the cross-examination of PW1. Hence, the payment of cost is condition precedent. Full stop. It is also made clear that pursuant to the cross-examination, the party shall proceed further, and the learned family court shall dispose of the matter expeditiously.
One submission.
Yes.
Much obliged, my lord.
There is an IA pending for the purpose of maintenance to the child, your worship. That may be also considered, my lord. Direction may be given to the effect to consider an IA which is pending under section 151 of CPC.
When was it filed?
It was filed, your lordship, in 2024.
Go ahead and lead your evidence.
At the time of the cross-examination, my lord, they have filed the
To
application.
do anything now, you want all IAs to be decided.
No.
Yes, my lord.
It's clearly apparent that you're only dragging on the proceedings.
Yes, my lord.
I'm
At the time of
granting
the
you one
cross-examination.
opportunity. Go and lead evidence.
Please.
Yes, my lord.
Otherwise, the court will deal with the matter. Yes.
Yes, my lord. Much obliged.
You wanted to say something?
Nothing, my lord. At the time of the cross-examination only, for the dragging the proceeding, they have filed that application, my lord.
The
Although
family
I am
court
paying
should
the
decide
education.
the matter.
Yes, my lord. Much
That
obliged.
you can file separate application for maintenance.
Please.
Much obliged. Much obliged.
And in case of any violation and deviation of the disobedience of the order, you're at liberty to go and file
Much obliged.
appropriate proceedings as per law.
Much obliged. Grateful.
Yes.
May I, my lords? Yes. My lords, this petition is filed against the order of the Honorable Principal Family Court rejecting the transfer petition, which we had filed before the Honorable Principal Family Court to transfer it from third additional to any other court. I had argued on this matter previously, my lords. Just to recapitulate, if this Honorable Court would like to lay down the law where litigants, unscrupulous people like the one present before you as the respondent, would browbeat the judges, make scandalous allegations, then I'm armed with case laws on those particular aspects. And this is very, very necessary today because this is what is happening in the Honorable Family Court. She dragged on a transfer petition for 9 to 10 months to give an offer for 20 lakhs as an extortion amount for divorce. Once that has failed, she withdraws her petition. When we file this petition, the impugned order would read and speak for itself, your lordships. The Honorable Family Court says there is a mandamus. That is why I'm not going to entertain this petition. Now, our division bench has laid down what has to be done in cases.
Are you questioning here?
I'm questioning the impugned order, which is rejecting the transfer petition on the grounds that the respondent herein is browbeating the judges.
Let us see that first.
Please. The impugned order is at page number 30 and
30,
my lords. And the reasoning starts from page number 32. May I read, my lords?
Yes.
From 32. This office
32.
32, my lord.
Hmm.
That is where the reasoning starts.
Hmm.
This office has received a memo through post forwarded by the respondent wife with
Read
reference.
from page 31.
Yes, my lords. This petition is filed under section 24 of the CPC to transfer GNWC 141 of 17 pending on the file of third additional family court. In the petition, the petitioner has made several grounds for transfer. In paragraph 12(1) to 1617, the petitioner has mentioned the day-to-day proceedings and what happened during those days in the GNWC proceedings. Along with the petition, during the hearing, the learned advocate for the petitioner has produced documents and additional documents. Considering the urgency in the matter, notice of this petition is issued through email to the respondent, who is representing in the GNWC as party in person, and also by hand to the petitioner with permission to serve the notice through email. May I proceed further? This office has received a memo through post forwarded by the respondent wife with reference to this petition. In the said memo, she expressed her inability to attend the court and she had filed miscellaneous 34 and 35 for transfer of GNWC and MC respectively from the third additional principal court. Those two miscellaneous petitions filed under section 24 were dismissed as withdrawn by the present respondent. From going through the documents produced by the petitioner, it is clear that on 23/4 in WP 18121, order of the Honorable High Court of Karnataka, pursuing the direction to the family court to decide the application filed as petitioner afresh by speaking order within 6 weeks from the date of receipt, certified copy of the order passed. The respondent wife has filed transfer petition civil 1752 before the Honorable Supreme Court. The said petition came to be disposed of by observing that they were not inclined to entertain the present petition as the proceedings in the petition are at an advanced stage and evidence has already commenced, and liberty is given to the present respondent, that is wife, to appear virtually. The same case had been to the Honorable Supreme Court. On 23rd September, two writ petitions, WP 5493 and 9057, they were filed by the respondent. Order was passed by the Honorable High Court of Karnataka and direction was issued by to the third additional family court, which read as under. The learned judge of the court below is requested to try and dispose of the pending matters within an outer limit of 6 months, consistent with the observations made by this court in WP number 14769 between N. Rajiv and so. Now, this mandamus has expired on 23/9/23 itself, my lords. I'm just pointing it out. I'll read further. Those petitions were filed before the Honorable High Court of Karnataka, challenging the order passed in GNWC number 141, dated 21/4, pending on the file of the third additional family court. There is a specific direction to the learned judge of third additional family court, as the Honorable High Court of Karnataka in the above said judicial proceedings has issued directions to the third additional principal judge to dispose of the pending matters within an outer limit of 6 months. I read further. The power of this court under section 24 is administrative power. Therefore, there is no need for considering merits of the case, as there is a specific direction to dispose of the matter to third additional principal family court. Under section 24 of CPC, this court cannot withdraw that case from the third additional court, either to keep it itself or transfer to any other court. Therefore, I pass the following order. The order says, issued by the Honorable High Court in WP number so and so at the time of passing is to dispose of the pending matter in 6 months. That is why our petition is rejected. Now, my lords, if I can point out her petition, which I have annexed along with this WP, her petition is annexed as annexure.
Who filed this petition under section 24?
First she files, then we file, my lords.
You filed this one.
This
What
instant one is ours, 121, my lords, miscellaneous.
filed by you.
Yes,
So you had filed this petition for transfer.
correct, my lords. We sought that
Rejected because of the High Court's order.
because of the High Court. The mandamus, which is quoted in that said order, has already expired, as I mentioned, on 29/3/24 itself. So this order is being passed on 10/12/24, your lordships. She cannot rely on that, is my first humble submission. Secondly, the gravity of the allegations made here, can the respondent be allowed to go scot-free? And it is a classic case and a rank example of bro-beating of judges. We have to demonstrate that, my lords. For this, I have asked an internal
this,
prayer.
This order passed on 10/12/24 in
Yes.
your miscellaneous petition.
Yes, my lords.
When is the order passed in the writ petition?
Writ petition order was passed on 21/4/22, my lords.
21?
21/4/22.
Hmm.
And the mandamus expired on 30/3/24, my lords. May I seek a correction, my lords? The order was passed on 23 September 23. I'm sorry. 23 September 23. And mandamus expired on 30/3/24. 6 months. Because we communicated the order on 29.
And when did you file your petition?
My petition was filed after her petition was disposed of, my lords. So my petition miscellaneous was filed on 2/12/24, my lords.
After the expiry of the mandamus.
Yes, my lords. The mandamus, because her petition was pending. Her petition was withdrawn in November. I filed mine in December. Her transfer petition was pending, my lords. Her transfer petition was disposed of on 23/11/24, my lords. Within 2 weeks, I filed my petition. And the reason given here is worth reading, my lords, as to why that transfer petition is disposed of. Because the first question asked by the Honorable Principal Judge was, are you agreeable to the transfer first? Irrespective of the mandamus of the Honorable High Court.
Yes.
And we said we would agree only if she withdraws all the allegations against the judges.
Come to the next point.
Yes, my lords. Now, my lords, given this scenario, why do we say it is browbeating of judges? In this period, she first makes allegation against the judges by filing both the petitions. We have filed only one because the other is governed by the mandamus of the coordinate bench of this Honorable Court. We have no problems with that. That is going on. In this GNWC, my lords, the transfer of custody takes place in the favor of the father. And 5 lakh rupees bail bond is executed by the mother because she has not only please let her not interfere. Let her not interfere when I'm arguing, my lords. I'm presenting my case as to why. So she has violated the orders of the Honorable Third Additional Family Court thrice, my lords, despite the undertaking. And that is why when we came before a connected WP before your lordships stayed the order of interim custody and said it should be done in Bangalore. Now, my lords, she complains to all the fora against the Honorable Judge, including the vigilance, for which we have a specific prayer here that this Honorable Court, in line with the Honorable Supreme Court's judgment in the OROP case, should ask for those reports because they all were kept in sealed covers. We don't know what has transpired. Then, my lords, there is a quantum shift. We come before your lordship in 2 cases where the judge is browbeaten into giving her interim custody in Malda, all throughout which was rejected so far in the JNWC. I can demonstrate that by the order sheets of the JNWC. That is our complaint with respect to transfer petition. The judge has been browbeaten. And this has been recorded by the principal judge herself while dismissing her transfer petition. May I point out the relevant portion, my lords, and the page number. This was a very clever strategy. And her transfer petition was alive for 11 months. Mine was not even for 11 days.
What is the stage of the matter now?
Yes, my lords. The husband, the father, has finished his evidence. Cross-examination is also concluded, except for a few excerpts which he has to mark. It is at an advanced stage with respect to her arguments. I'm sorry, her evidence. She is the respondent there.
The proceedings is only GNWC 141.
141. Now, before yourself, your good self, in this case, my lord.
That is the only petition that is pending.
No, the other one is 4679, petition filed by the husband for divorce under Section 27, Special Marriage Act.
Both are before the same court.
Same court.
So you filed this transfer petition for what?
For transfer, the reason being, my lords, the other case, the Honorable Third Additional Judge has made a reference to the Honorable High Court under Section
Want a
113.
transfer from third additional
To any other
court to principal family court.
Yes.
So in the principal family court, the MC case is pending?
No, my lords, MC case is also pending before the Honorable Third Additional only.
Why you want transfer from this?
I'm explaining, my lords. In the MC case, the Honorable Third Additional Judge has made a reference to the High Court on a point of law under 113 of CPC, saying that there are two petitions, one in Malda filed by the wife and one by the husband in Bangalore. So though it is not hit by the principles of res judicata, it looks like I need guidance as to what should be done in such a scenario.
Total confusion.
Now that is pending before a coordinate bench in Court Hall number 7, my lords. So we are not touching on that because that decision will be taken by the coordinate bench therein. We are aggrieved by the two orders which were passed by this honorable court after the bro beating, and she ordered for custody of the child to Malda, which was itself protected by this honorable court and the predecessors all these years because the child was separated from the father for the last 5.5 years. Now, from the last 2.5 years, child is with the father. He is allowing absolute access every day virtually, as well as whenever she is in Bangalore, she is welcome to have contact rights with the child. She has relinquished the custody of the child herself when she first got interim custody. So we are aggrieved by that.
Make some sensible.
Now, my lords, if I can use the case laws, because I want to demonstrate the seriousness of this particular case as to how she makes allegations. The allegation is not only against the judges, it's against the counsel as well as the litigant to the extent that we have entered the chambers and we have brokered some type of a tactic.
Lords,
That is the
stick
seriousness
to the
which is on record here. So this honorable court has held what to do, a division bench headed by the Honorable Chief Justice in such cases when reckless allegations are made against judges. And if we do not take up this with an iron hand, then this continues because she comes before the principal judge and says, I have complete faith in the Honorable Family Court now that she is getting favorable orders. She has been browbeaten because the vigilance had done an inquiry. There was a closed door meeting. There were records called for.
There in this petition.
All that, no, we have stated everything. I have averred everything, my lords. There is not a single thing which I'm taking out of the petition.
In fact, para 25, he's done everything, whatever he's complaining, my lords.
And my complaint is that the respondent is browbeating the judge.
Kindly see para 25 of his own petition, please, my lords. He's trying to overcome all of that.
I am definitely
Very,
not
very
overcoming. I'm
contemptuous,
supporting.
Statements about the presiding officer of third family court judge.
That is my allegation that you are
I can
browbeating
see
the
that, my lords.
judge.
The petition before this honorable court, in the face of this honorable court, what the petitioner has to say regarding the reputation and integrity of the honorable judge,
Conduct of the respondent is explicated here.
for which I put an IA.
No such IA has been served on me, my lord.
Is there wide mail?
Nothing like that is there, my
Honorable
lord.
will not even take it also. I
The-
don't want to make
The
any
first,
submissions.
the
It's
first
not in
title
my
also
blood. I'll
doesn't
never
show
do that.
anything like that, my
I'll
lords.
never do that. Lord, the filing counter, they don't even accept, my lords, if you don't give the copy to the opposite parties, which you have done by mail. And I have the hard copy also.
Nothing is reflected in the cost title.
The
Where is
petition,
the order of the High Court in WP 5493 and 90?
Yes, my lords.
it is in his petition, I think, annexure L, please, my lords.
Yes, my lords. Annexure L, page number 257, my lords. And these two petitions were filed by the respondent. They were not filed by us, my lords.
But you were party to it. You were there. You're bound with them.
237.
237, my lords, yes.
4
Running,
numbers.
running page, my lords. 37, 38,
3rd September.
yes. In this case, my lord, she has sent emails complaining about this learned senior advocate appearing in this case also.
Order, please stick to whatever documents are there before this honorable court.
She writes to every forum.
There's nothing like that over here.
What is the order?
May I read, my lords? The
Yes.
order is at page number 239. Learned counsel for the respondent submits that these petitions have become infructuous in view of the apex court order dated 12/5/23. The Honorable Supreme Court granted us and also
Please read
became
the order.
also because of the summer vacation already gone by. There is none to oppose the submission, and therefore the court assumes the submission to be true. In view of the above, these writ petitions are disposed of, reserving liberty to the petitioners to seek their revival if the submission of the respondent is not true. The learned judge of the court below is requested to try to dispose of the pending matters within an outer limit of 6 months, consistent with the observations in Raji versus Deepa. This was dated 23rd September, my lords. The mandamus expired on 30th 3/24.
Yes.
May I point out the seriousness of the allegations for a moment, my lords? Then I would beseech your lordships.
Please restrict yourself to the writ petition. What is there for us, this court, to go to the seriousness of the allegation?
Yes, my lords, if there is an allegation against,
Please restrict yourself to the petition.
I am on the petition, my lords.
No, you're here for what?
I'm on the
What are you
petition.
challenging here?
I'm on the petition, my lords, and the Honorable High Courts, other than this Honorable Court, the latest being the Honorable High Court of Delhi, if I can persuade, has laid down guidelines of transfer petition rules in cases where allegations are made against judges. I couldn't find a better judgment than this because all the Supreme Court judgments are covered here. That is our allegation. If your lordship permits, I will.
There is an order passed by this court
Hmm.
to dispose of the matter
Within
within
Correct.
outer limit of
She
6 months
defeats it by filing her transfer petition.
before the family court.
Yes, my lords, she files for 11 months.
After this mandamus order.
Yes,
Then what-
after this
what
mandamus
happened?
order.
What happened there?
She keeps it pending for 11 months. And may I show the final order, my lords? That is very, very interesting.
So that the only matter that was pending was GNWC.
And 4679, she files 2 transfer petitions, not 1.
There are 2 diverse petitions.
She files 2 transfer petitions. That order is from page number 75, my lords. After keeping it pending for 11 months.
25.
75, my lords, running page. One is miscellaneous number 34, which is for the GNWC, the impugned order now in. And one is miscellaneous 35, which is for MC 4679. So she files in both.
But he files the petition after the orders are passed.
And as on that date, my lords, the mandamus was existing. Please appreciate.
The Lord's High Court order is passed on 23/9/24. He files the MC for a transfer again on 2/12/2024.
She's again giving false
And I say on the
information.
record, your own documents are speaking.
23/9/23, not 24.
1 minute, don't do cross argument. You want to do that, you can go do that in the corridor.
Please,
But too
let me
eager.
out. It's my case.
All right, this miscellaneous 34 is filed
Yes,
for transfer of GNWC
Same case.
141 and divorce petition 4679.
yes. She has made a common prayer, but there are 2 petitions, my lord. 34 and 35 are there.
Where is 35?
35 is annexed after that, my lords. Yeah, I'm carrying the hard copy, my lords. I have not annexed it. I beg your pardon.
Miscellaneous 121 is being challenged before this honorable court, my lords. I don't know why attempts are being made to confuse this honorable court.
So that petition filed by you came to be withdrawn.
Yes, my lords. Yes, my lords. Because unfortunately, there was some confusion between the advocate on record for the respondent at that point of time.
All right, so
and it
that
was
is not
high court.
anyway concerned with
Yes, my
this.
lords. That's unnecessary, my lords. This is just an attempt to confuse this honorable court. It's a very, very simple case, my lord.
This is 35
Literally, it is
and what I've
150,
attached is 34, my lords. 35 was filed for 4679.
What happened in this case?
Yes, my lords. May I read page number 70? May I read the orders of the Honorable Principal
Please
Family
tell me
Court?
what happened in miscellaneous 35 of
Both
24.
of them were withdrawn, my lord.
All right, that's all.
Yes.
That's not required further. Tell me, come to this point
Yes, my lord.
of 121, your case.
Now, my lords, on the same grounds, because she browbeat the judge, we filed 121. And our allegation is that earlier, the judge was not biased. The judge was upholding the principles of natural justice. She went to the extent of, it is one of my points of pleading, that she did not allow in-camera proceedings, though it is a statutory proviso, quoting that I cannot ask everybody to go out and stand in the corridor. That was the gravity. And she's giving custody of the child to Malda, which is outside the jurisdiction of the family court, which violates the direct mandamus of the Honorable High Court and what has been held by the Honorable Supreme Court, that we have to adjudicate only in Bangalore.
No,
Most importantly, my lords,
false submission.
if you make such allegations and browbeat the judges, I am covered by citations. I want to go point-wise and say why action should be taken and why my petition should be allowed. Now, first principle which was violated by the principal judge was she never called for a report from the judge or the alterum partum. As per the guidelines of the Honorable Supreme Court is not only applicable to you and me, it is applicable to the judiciary as well, wherein we should ask the judge also why this allegation is coming and a report should be made. Then the judge would be in a better position so that the alterum partum is applicable to everybody. Now that principle was violated. If that was done, I fairly submit, my lords, this petition would not have been disposed because she would have given a status and a report as to how she was prevented from doing her judicial duties. Second point, my lords, after that, when we asked for this particular case to be transferred, the mandamus was not in existence. When her petition was filed, which was with the sole intention of defeating the mandamus, because they did not want the custody to be relinquished. They did not want us to win the battle. They did not want all the evidence to come on record. She stopped appearing. And the allegation now being made is that counsel had problems with the third additional. That is the memo which has been filed, which is even more serious. Now, first she makes allegations. Now she says the counsel makes allegations. This further adds to browbeating. My internal player in the main is also to call for records of this particular case with respect to the registrar judicial, registrar vigilance, also the principal judge, and obviously the lower court records, because then only we will come to know what has transpired, my lords. So these were violated. And as I mentioned in the judgment, which I'm waiting to peruse, the Honorable Delhi High Court has laid down guidelines in such cases as to why bias. In fact, Cambridge, the Black's Dictionary, all the meanings with respect to bias and how judges may also not be infallible. Most importantly, if a decision has gone against and then they again come and adjudicate the same matter, what happens? Also that the judge should look at the factor that he should not or she should not think about the fact that I am biased. He should put themselves in the armrest of the party and think in such a situation what the party might expect. In fact, this case stemmed out of a simple incident that the wife heard the judge on video conferencing and the allegation was made. The Honorable High Court of Delhi has laid down stringent guidelines after that. This is even more serious, my lords. The first allegation is that the judge sends her out and speaks to us in private. Second allegation in the petition is that when she goes out, we go to the cabin of the judge and we are speaking in private to the judge. The third allegation is that the Honorable Judge is always finding ways to settle the matter, and that has been recorded by the principal judge. The last amount arrived is 20 lakhs, my lord. In fact, afterwards, they went back on that also. They want 20 lakhs plus they want a flat in Bangalore. So, according to me, my lords, my humble submission is this is a very serious matter, because if this is not stemmed, then she continues in the same manner again and again. And I'm also supported by the division bench judgment of this honorable court. Just 2 points on that, my lords. Here, the judiciary is on par, my lords. That is what the honorable division bench has headed by the Chief Justice of Karnataka. 1 lakh rupee fine was was actually attributed to the petitioner who made those particular allegations. And like this particular case, they tried to withdraw. That time, Order 4 Rule through and Sub Proviso 3 came into the picture. The Honorable Division Bench did not allow them to withdraw because they had made those scandalous allegations. They told them to withdraw the entire allegations, else contempt action would be initiated against them. This is what we are also looking at.
Transfer petition. Where is your transfer petition?
My transfer petition is at page number 50, my lords, 50. Whatever I've argued now, I have systematically given as my grounds over there, my lords. In seriatim.
With absolutely no supporting documents. You can say anything.
It goes up to page number 57, my lords. And if I was given a hearing there, my lords, I would definitely not have been before this honorable court.
Is your ground seeking for transfer?
Yes, my lords. My grounds starts from page number 57, my lords. Here, I have reproduced the incidents of the order sheets to demonstrate browbeating, my lords. I have attached the entire order sheets for the perusal of this honorable court in GNWC, my lords, as annexure. As annexure G, my lords, page number 93. So on a day-to-day bench basis, I have mentioned what has happened. My lords, you'd be surprised. This honorable court by a mandamus in WP number 18191 in the year 2017-18 itself restricted her from writing any letters, private communication to the honorable judges. Till date, she has written 54 communications, my lords.
It is highly
Our IAs for contempt are pending before the honorable judge, but she takes up her IA, which is for transfer of custody or interim custody, which is towards Malda. Now that is the allegation we are confronting here, because despite the mandamus, now that is contempt as defined as 2C. A reference can be found in criminal contempt section 15 also. The honorable judge should have done that. Then, my lords, when the warrant was issued, she in Malda makes sure the warrant is not executed. Then we had the Honorable CJM arrest her in this particular case. And transfer of custody was an even more bigger issue, my lords, because she was told to arrange the admission of the child in a school in Bangalore. She goes and puts the child in Wilson Garden Government School, my lords. Now she's studying in an international school. She has got all the curriculum vitae required to have an enhanced career and a bright future. All these allegations we have brought out in a systematic day-to-day life, which has happened with respect to the GNWC. Now, the most important thing is at page number 56, my lords, I have given the dates. When there is no stay, the Honorable Third Additional Judge says, I cannot touch this matter because she has filed transfer petition despite there being a mandamus. Please appreciate, my lords. That is the crux of the matter. So they wanted to defeat the mandamus. That's why they kept it pending till November. Once the mandamus is defeated, the Honorable Trial Court Judge does not write for extension. I come to this Honorable Court and I ask this Honorable Court via an IA, can you please extend? I am told that I cannot ask for it. The Honorable Trial Court has to do it. That is recorded by the Honorable Judge. In fact, the memo is rejected. The IA is rejected. She still does not do it. After this, my lord, the vigilance complaint, I mentioned the dates, the emails, and the most important part, my lords, when I file RTI, when I file certified copy applications, what was granted to me earlier by the same judge is now being rejected by the judge. I am not being giving transcripts of the emails and private letters sent by her, but they find a place in the order sheets. So that entire bunch has now come to the Honorable High Court in the reference letter under section 113. And the Honorable Coordinate Bench in Court Hall number 7 ordered them to give us a copy of it. Still, they have not given us a copy.
What is the matter pending in Court Hall number 7?
Yes, my lords, the MC petition 4679, because jurisdiction violation has happened under section 31. She has filed MC in Malda and he has filed MC in Bangalore. The question is, where should the MC be filed? That is the reference she has asked. So under section 31, my argument is she is not eligible to file in Malda. She should have filed in Calcutta. And from the last 7 years before separation, because they separated in 2016-17, they were staying in Bangalore. So jurisdiction is vested in Bangalore, not in Malda. That reference, the Honorable Third Additional Judge has sent to the Honorable High Court. So
What reference?
what should I do about these two petitions? Because there is a double petition and I cannot hold this as res judicata is her submission in the letter of reference, my lords.
Reference is made to the High Court.
Yes, my lords.
Under which provision?
Under 113
Read
of
113.
CPC, my lords.
Read 113.
Please. May I read, my lords? Reference to the Honorable High Court. Subject to such conditions and limitations as may be prescribed, any court may state a case and refer the same for the opinion of the High Court, and the High Court may make such order thereon as it thinks fit. Provided that where the court is satisfied that a case pending before it involves a question of law to the validity of any act, ordinance, or regulation, or for any
But where are
provision.
you reading?
My lords,
Where are you reading from?
I'm reading from CPC, section 113, my
That
lords.
is CPC.
Yes, my lords.
What you're reading is CPC.
Yes, my lords, section 113. That is how she has made a
Whatever
reference.
you're reading is not in CPC, which I have.
I am reading the soft copy, my lords.
I don't know of the genuinity and of that, whatever you're reading. Why can't you get your CPC?
I'm highly apologetic, my lords. I just rushed in. Court, may I borrow? I'm reading section 113 of CPC, my lords.
All right. Yes, come to your application.
My petition, my lords?
Yes.
Yes. My petition starts from page number 11, my lords, brief facts, and then my ground starts from page number 20, my lords. I've reproduced in seriatim. And in page 24, I've highlighted in 29 as to why we had to file this particular petition for transfer. Page 24, my lords, in point number 29. Please see pointers 29, 30, 31, 32 onwards, my lords. Because all this happened in open court, it's recorded in the order sheets and memos which have been filed.
29.
Yes, my lords. Page number 24, 39, my lords. May I read, my lords?
Yes.
The Honorable Third Additional Family Court pronounced the summary of the order on IA number 53. However, the entire file along with the detailed order was not released by the Honorable Third Additional Family Court until 510. because last time a hue and cry was made as to why we came so late to the honorable court. And when we received the certified copy, even though we made efforts requesting the court officer to persuade the honorable court to release this file early. Next, on receiving the certified copy, we prepared the draft overnight, challenged the order IA number 53 dated by this honorable court, which got registered in the Honorable High Court as WP number 27564 on 8/10/24. This was for the Dasara vacation. On 23/10, the advocate for respondent in miscellaneous 34 submitted in the open court that they have complained, I would not read further, my lords, against the honorable. Then, my lords, on 15/11, she filed IA seeking interim custody again because 53 was defeated. And the 60 IA was impugned before your lordship in the vacation period. This is what has been happening afterwards. We are aggrieved by this, my lords. And this is, according to us, classic bro beating by the judge.
Bro beating by the judge.
I'm sorry, of the judge.
That's what he has said even in para 25.
Yes.
Yes, ma'am. That is my, yes, yes.
Please,
I'm supported by citations, if you permit.
Yes.
Please. Bench work, okay? Can I pass on? This is of our Honorable High Court. And as I mentioned, the Honorable High Court of Delhi, persuasive value, my lords, with all the citations of the Honorable Supreme Court has laid down guidelines.
You made a list of it?
I have not made, I'll file it with a memo, my lords.
This is not the way to give citations.
I understand, my lords. I understand.
When you understand everything, why don't you give it?
Please forgive me because I just came in.
This is the first time you're appearing in High
my lords. I was online before the Honorable Supreme Court. That's why I should have taken some time and then prepared. I'm very sorry, my lords. My apologies.
Give one copy to her.
It's given. I'll give the copy.
Yes, what do you want to read here?
Yeah, in this, my lords, first I will take the division bench judgment of our Honorable High Court, my lords. Here, the same tactic was used by the respondent hearing in internal page number 7, my lords. Our lordships have clarified why that practice should not be allowed, why they cannot be allowed to withdraw.
Which
And,
paragraph?
In internal page number 7, it starts at para number 9, my lords. May I read?
Yes.
Para number 9. And an unexpected and expected delay tactic was attempted by the petitioner to ensure that this petition is not heard today. After the case is called out today, the learned counsel appearing for the petitioner submitted a memo of retirement in which it is stated that he has informed the petitioner that he would not be continuing in the writ petition and he has told the petitioner to take the file and no objection. When this memo was presented at 11:30, we invited the attention of the learned counsel appearing for the petitioner to the provisos of Sub-Rule 2, Rule 4, Order 3 of the CPC. We pointed out that the learned counsel appearing for the petitioner, it is the discretion of the court whether to permit an advocate to retire or not. We therefore make it very clear to him that we will not allow the said counsel to retire by exercising discretion which is vested in this honorable court. This petition was therefore passed over when the learned counsel appearing for the petitioner a memo of withdrawal which contained the following statements. This is the backdrop, my lord. Same thing happened in our case also. She does the same thing. And then the statement was made. Now,
Madam, have you read the judgment?
My lords,
now,
now if somebody gives a representation to that presiding officer, it's between the presiding officer and that person, whether he wants to withdraw.
Let him argue his case. Why are you interrupting?
Now, my lords, this honorable court has commented on it in page number 11. And the sequitur starts from para number 12. May I read, my lords? Because allegations were made, they did not withdraw the allegations. Then they say we are retiring and we are going to withdraw the petition. May I read?
Who was retired in the case?
First, the advocate tried to retire. And then they said we will withdraw the petition.
In which case?
In this case law, my lord.
Your case.
In this case also, first her advocate said we will withdraw. And most importantly, she appeared as party in person, then withdrew the petition, despite the scandalous allegation against the judges. So our Honorable High Court has said, in terms of sequiturs, why this action cannot be allowed.
What the court has done.
The court has allowed it, my lords. The lower court.
Don't challenge that.
I understand, my lords.
Don't challenge that.
That was my ground in my petition.
That you have not challenged.
That was my ground in my petition because
Which
she did
petition?
not use Order 23 and seek liberty. It was just a memo given. And the mandamus had already expired, my lords. That's why I made it a point to put it as a ground in my petition.
For transfer,
Yes, my lords.
because she was permitted to retire.
No, because she made the allegations and no action was taken against her when the withdrawal.
What allegation
happened.
was made?
Against the judges, my lord.
What
in her
allegation
petition.
was made?
I repeated those 3 allegations, my lords. One is that the judge sends her away and has private talks with us. We go into the cabin and we are setting up some type of a broker. Most importantly, she is not giving her custody despite the fact that she had sought custody and she is in Malda. Those were the allegations, my lord.
All right. So this was made by the respondent
By the respondent,
herself or through a counsel?
the verifying affidavit is signed by her, my lords,
No, she was represented by a counsel.
by a counsel first.
For that reason, you wanted transfer.
I wanted transfer because of the fraud played on the honorable court by making those frivolous allegations, keeping the petition pending for 11 months and no transfer being given. May I read further, my lords?
Yes.
Page number 12, para number 12. The action of the petitioner, which is nothing but serious attempt to scandalize this court, has to be condemned in the strongest possible words. As stated earlier, one of the reasons why we are not initiating suo motu contempt action is that we'll be guided by the principles laid down by the apex court in Regina's case. They found it, my lords, but towards the end, in the order final, may I read para number 16, my lords?
Yes.
Therefore, it is a FIS case where the petitioner should be saddled with exemplary costs quantified at 1 lakh. The costs will be payable to the KSLSA under the directions of this honorable court, has been directed to coordinate with the activities of assisting for toys and
What is this
and
prayer?
etc.
What is
After the total amount is paid, they were said that if you do not withdraw with your deepest apologies, we will initiate contempt. So she was not allowed to go scot-free, my lords, the person hearing. And the other judgment I'm relying on, which is the Honorable High Court of Delhi, my lords. May I just point out the page numbers, my lords? And the guidelines in the final.
Yes.
The audi alterum part is highlighted in the first page itself, my lord, under Constitution of India, Article 14. Principle of audi alterum partem has to be applicable and judges have the right to be heard. Now, about the 5th line thereof, my lords. However, when the conduct of a judge itself comes into question, the principle of audi alterum partem must be equally applied in such cases to the judges. I'll find support of this in paras numbers 72 and 73, my lords. The entire sequitur has been explained there as to why this should be done. May I just read for the benefit of this honorable court? However, where parties perceive that they can manipulate the judicial process by casting doubt on a judge's fairness, it sets a dangerous precedent. If it is a general perception that some litigants attempt to manipulate the system by indulging in frivolous claims aimed at court hunting, where litigants seek to have their cases heard by judges they perceive as more lenient. The support I find is in paras internal 72 and 74, my lords, which is at internal page number 19, my lords. In 72, in the hard realities of the legal profession, it is not uncommon for some judges to be perceived as more lenient or relief giving, while others are viewed as stricter or less. Such perceptions, whether accurate or not, can influence how parties approach their cases and strategies they employ. Nevertheless, it is crucial to remember that every judge is bound by same principles of law and justice and strives to apply them impartially and fairly, irrespective of any preconceived notions where the parties or the counsels may hold about them. As long as the legal principles are applied impartially and fairly, irrespective of the outcome of the order, the party not getting any relief cannot allege bias against him. The perceptions about a judge without there being any material showing bias has to remain within the realms of perception and cannot be taken on the cannot take the place of evidence of bias.
Yes.
And they have given beautiful banters about the bar and bench, and the final directions is in page number 23, my lords, paragraph 106, 1, 2, 3, 4, as to how a transfer petition has to be dealt with. In fact, CRPC has also been discussed, CPC also, my lords, but I rely on the CPC equivalent.
You want this honorable court to tell that court how you have to handle it. All right. What is your petition? What's your prayer?
With that, I beseech this honorable court to allow my petition to transfer it, because I believe, as I've demonstrated from the judicial records, not only there is no semblance, but there is an eventual possibility that justice would not be carried out. And now the judge would be faced with the inevitable task of having been browbeaten and going against her own judgments, which has happened previously, madams. I will give a reply instantly, madams.
Well, very briefly, Malats, I have different objections also. Very briefly, Malats, the prayer that the petitioner is asking here is to issue a writ of certiorari to set aside and quash the impugned order. He has read the order also, Malats. Now, what is really very confusing is the petitioner really very sure of what exactly he wants? He says he wants a transfer. He himself has attached the copies of the Honorable Supreme Court as Annexure K, where he himself before the Honorable Supreme Court, my lords, if my lords can just see Annexure K, my lords, which is at page number 233 of his own petition. In para 233, there are 2-3 numbers, my lords, but Annexure K, 233, 215, 234, one of those. Para 2, my lords, learned counsel for the respondent husband states that the proceedings of the captioned petition are at an advanced stage and evidence has already commenced. The respondent is presently under cross-examination. In the given facts, we are not inclined to entertain the present petition. My lords, I'll very humbly pray that this honorable court just remembers this, what exactly has been recorded with the Honorable Supreme Court and what the petitioner has pleaded in his pleadings in para 11, my lords, a totally false and a misleading statement made before this honorable court. My lords, as per this, the transfer cannot happen for a simple reason that the entire proceedings in GWC 141 of 2017 is in an advanced stage. Hence, it cannot be transferred. This is one important reason where the petition before this honorable court fails. Second, my lord, he has again relied.
Who was filed this petition?
The respondent wife, my lords.
Before the Supreme Court?
Yes, my lord.
For transfer of?
Transfer of this GNWC case, my lords, to the district court in Malda.
From Karnataka to West Bengal?
Yes, my lords. To the Court of Learned District Judge in Malda. There, the submissions were not with regard to jurisdiction or for anything else. Absolutely nothing is recorded. But what is recorded is the fact that it is in the advanced stage of the proceedings, hence it cannot be transferred. Because the family court judge is already aware of all the facts, hence it should be tried there. That was the only thing. But kindly come to para 11, please, my lords. Kindly see what he has pleaded in his page number 20.
What has happened in the Supreme Court after that?
Well, that's all. They have disposed the petition with this finding. That is it. Like, let it go on. And liberty, my lords, has been granted as per para 4. However, if the petitioner wife finds herself in some difficulty in leading her evidence or in cross-examining the respondent and or his witnesses, she is at a liberty to approach the family court for permission to do so virtually. If such a request is made, the family court shall consider the same and pass appropriate orders. Which, my lords, she is putting those applications and they are even being considered to a great extent, my lords. No complaints on that. Now, my lords, so this is one reason which he himself has given as an evidence before this honorable court. His petition 34901 does not stand at all, my lords. Coming to Annexure L, please, my lords, which he has vehemently said that there's an outer limit of 6 months. He is very well aware of that. In spite of that, he again puts an petition asking for the transfer without any proper valid reason, aware that it has to be completed within 6 months. Hence, my lords, the grounds that he is beseeching before this honorable court that it has to be transferred does not stand the test of law. In fact, the court order which has been recorded, my lords, which my learned friend even read from page 31 onwards. There, my lords, the Honorable Third Additional Judge has recorded in page number 33, my lords. The respondent wife has filed a transfer petition 1752 of 2022 by observing that they're not inclined to entertain the thing because it's an advanced stage. It is there on the record. The court has also recognized that the outer limit to complete this entire proceeding is only 6 months. So based on these two judicial reasonings of the constitutional courts, both the Supreme Court and the High Court, the Honorable Third Trial Court, the Family Court, is bound to go by these orders. Hence, at this point of time, we will not transfer. It's a very, very well-reasoned judgment, my lords. And I humbly pray that it doesn't really need any kind of an interference. But, my lords, after going through the pleadings, my lords, I filed an IA with a prayer that criminal contempt proceedings be initiated against the petitioner for two very important reasons, my lords. If I can take my lords.
That IA is not
Before
served
this
on me.
court.
Yes,
That
my lords.
IA is not
Okay,
served on me. It is not there in the cause list also.
My lords, please.
No, it is not served, my lords. I repeat,
You're referring to some application you have filed in this petition.
Yes, yes, my lords.
there is no
Yes,
IA in the cause list.
Please, my lords, if that IA is seen, my lords. It was filed yesterday. And my lords, if you open the first page, my lords, inside we have to stick the proof that we have served it onto the petitioner.
I
By
don't have the
mail,
IA, my lords.
Which, my lords, I have done it. I even pasted that. I don't have to make any false submission before this honorable court. my lords.
That no such IA is listed
Correct.
today.
Unfortunately, my lords, I think I can go and get it now. I had submitted yesterday. I don't know if something else has happened, my lords, because I went at 2:30 and that court officer, I'm sorry, the pending staff said that he has put it with the file. How come it is not there? 2:30 ನಾನು ಕೇಳ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ಹಾಕಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಹೇಗೆ ಬರೋದಿಲ್ಲ? It is just to frustrate that IA, my lords. He is talking of contempt put before that court, this court, and things like this. Contempt is in the face of this honorable court, my lords. And which very judiciously, my lords, in the filing counter, they don't even accept your objections or any copy, my lords, if nothing is served to the other party, which have done it by mail. Sorry, my lords, which have done it by mail.
I vehemently
I hear, my
reiterate,
lords.
my lords, I do not have
My
the
lords,
hard.
if it is not there, my lords, I will run down immediately within 2 minutes. I'll ensure it is before this honorable court. Because
I
at
have
2:30
that IA, 1 of 25.
Yes, my lords. If you can kindly, my lords, just turn the first page, my lords. We have to stick that there, that we have sent the petition by mail. It's only after he has received that, he's started, concentrating more on the contempt, because he knows he's caught here. My lords, if my lords, the pleadings in this writ petition, para 25, please, my lords. This honorable court's conscience will be shocked. Can a petitioner talk about a judge like this, a female judge like this? Para 25, please, my lords.
Para?
25 of his writ petition, my lords. Please.
Yes,
It is on the face of this honorable court, my lords.
page
The-
25.
No, my lords, para 25, my lords.
Of?
Page 27 of his petition, my lords. Para, I think page 27, he has put so many multiple page numbers.
Yes, para 25.
Please, my lords. The petitioner states that the Honorable Principal Family Court Judge erred in becoming a part of the browbeating tactics of the respondent in defeating the mandamus, stated supra. In fact, aiding her extortion divers ranging from 2.55 crores to 20 lakhs as judicially noticeable from the order sheets in Annexure F. My lords, what would this honorable court really have an opinion with regard to such a kind of blatant, scandalous statement made for a lady judge of the family court? Please, my lords. Is he trying to say that she's become part of the browbeating? Is he trying to say that the honorable judge is some kind of an antisocial element? Is he trying to say that she is an extortionist? Is he trying to say that she is in fact aiding her extortion divers ranging from 2.55 crores to 20 lakhs? Is this the kind of pleading you make before this honorable court, my lords? Can he talk like this about a lady judge? Has he got any evidence, my lords, that the honorable judge was part of this extortion? He calls the maintenance which is judicially granted by the act as an extortion technique. And he makes this blatant allegation, the outrageous allegation before this honorable court, telling that the trial court judge has been aiding.
Yes.
Hence, my lords, and my lords, para 11, please, my lords. This here, my lords, in para 11 of his own petition. And I've got a few Supreme Court judgments also, please, my lords, which I would be very grateful if this honorable court, please, refers, please. My lords, para 11, at page number 20, in multiple pages, 20, I think page 20, please, my lords. Para 11. My lords, here he says, what the Supreme Court says, he has not recorded that. He has put his own interpretation, my lords, that the respondent filed TP 1752 of 2020 before the Honorable Supreme Court of India on 17/8 to transfer this so-and-so from Bangalore to Malda, which got disposed on 12/5 in favor of the husband petition, and the Honorable Supreme Court of India refused to interfere by holding Bangalore as a jurisdiction. Such blatant lies. Nowhere in the order of the Honorable Supreme Court has the Supreme Court come to this inference that this petition has been disposed with the finding that Bangalore is its jurisdiction. A totally false statement, my lords, trying to mislead this Honorable Court. Such petitioners, my lords, who are common citizens, who make this kind of blatant false statements.
What is this?
Such. My lords, if.
You have received that copy of IA?
No, my lord.
My lords.
But
I
your
think-
client has received it by email, I guess.
My lords, yes,
I'm
my
not,
lords.
because
But take
is
a
not
printout
correct,
and come back.
because I am the counsel. It has to be sent to me. It is not sent to
Can even
me.
go to the respondent, we don't know
course.
where you stay. My lords, he can have a copy, my lords, I'm giving you
It
his
is not
hard
even,
copy now.
yeah,
He
it
can
is.
A copy.
find
Yes,
it.
yes,
my
yes.
lords, I'm giving.
I'll refute it
But-
immediately.
That's the reason, my lords, he started everything with the contempt only. This itself proof that he knows where this is going to come. My lords, if
We'll
my,
hear you later after they let him go through that IA.
No, I'll refute.
please, my lords, please,
No,
my
no,
lords,
please continue, my lords. I'll refute.
please, my lords. Very grateful, grateful.
Record. Learned counsel for the petitioner and learned counsel for the respondent are present. Learned counsel for the respondent has filed IA number 1 of 25. On serving the copy of the same by way of email to the petitioner, but learned counsel for the petitioner has not received it. However, a hard copy is furnished today in the open court to learned counsel for petitioner. He shall file objections, if any, to the same. Call this matter after a week. Yes, go through that.
Yes, my lords.
Can file your objection, I'll hear again. Otherwise, there's no point now.
Grateful, my lords.
Yes, next.
I'll not take more than 2 minutes of your time, my lord.
Who's opposing? Where is Mr. Hegde?
Mr. Hegde seems to be online.
Oh, you are. No
I'm
one-
for the appellant, man.
This is the case that you are not even a party.
Yes. I'm neither the owner, neither the insurance, neither the claimant. My lord, that is my humble submission. The date of accident is 4/5/2019. ma'am. I'll be very brief in my submissions.
Yes.
The date of accident is 4/5/2019.
You are K.S. Vasavi Prasad.
Yes. Now, my lord,
ಇದಿರಲ್ಲ ನೀವು ಅದರಲ್ಲಿ. You are respondent number
I
2.
I will take.
So in the tribunal, you are respondent number 2.
ಹೇಳ್ತೀನಿ, my lord. I'll go through
You
it.
can't say you are no one.
No,
You should say you were
I'm not an
arrayed-
owner. My submission.
You were arrayed as respondent
I
number
responded.
before the tribunal.
Yes,
You
but
can
I'm
have-
making a submission that I'm not owner, I'm not claimant, I'm not insurance company. That's my.
You have made a party.
Made a party. That's my humble submission. My lord, annexure B at page number 55.
That is a claim petition.
Yes, claim petition. Respondent number 2, K.S. Vasavi Prasad. Below the address, within bracket, present RC owner of the vehicle is stated. Below that, respondent number 3, Anand Kumar. Below the address, owner of the vehicle. Now, my lord, in Motor Vehicle Act, there can be only one owner.
Huh?
There can be only one owner. RC owner and owner is not there in law. That is my first submission.
No. What?
My
Without
submission.
even going into the merits, I don't even know what your case. What probably he wants to say is present RC owner of the vehicle is you.
That is what comes through this claim petition. Is written like this.
Written.
It's written like this. So that is what I brought to the knowledge of.
Maybe you have sold it. But to third respondent.
Yes, way before accident.
Maybe.
RC is also transferred.
I don't know. I'm just assuming.
You're right, my lord.
So RC owner in the RC book must be your name.
Allowed.
And then you
Hey,
have,
health
sold,
thing.
you have sold it to R3?
R3, Anand Kumar, way before, 1 year before the accident, RC was transferred also. But maybe the claimant did not know. Let's put it this way. On page number 15, page number 57, clause 15, name and address of owner of the vehicle, K.S. Vasvi Prasad and Anand Kumar.
Yes.
Address. So and so. Page number 58, para 3, my lord. I will read from last but 8th line. The second respondent is the present RC owner and third respondent is the owner of the said vehicle. Now, I'll just stop there. So one, he says RC owner, maybe due to lack of knowledge. Fine, no problem. Now, statement of objection is filed by my clients. Now that my lord will find at Annexure D, page number 63. On page number 64, para 6, my lord, the respondent number 2 submits that the said vehicle, Bajaj Auto Rickshaw so and so, was sold by him to one Mr. Anand Kumar, who is shown as respondent number 3 in the above petition, and third respondent is the present owner of the said vehicle.
This is precisely what I said.
You are right. That is what I said.
I have not even read your papers.
I have. I will go further.
Though I have not read your papers.
Yeah, you were right, my lord. Intuitions were perfectly right. Further, respondent number 2 has also transferred RC, and other necessary document in favor of third respondent and also issued delivery note. But the insurance policy stands in the name of respondent 2. It is pertinent to mention here that respondent number 2 has also application for transfer of insurance. The third respondent has also issued sale receipt in favor of second respondent. Kelkede para 9 jote, last but 3 line. Respondent number 3 being the owner of the vehicle and the respondent number being the insurance of the vehicle are liable for payment of compensation. This is a stand taken by the appellant herein before the trial. Now, subsequent to this, issues are framed. That is at Annexure email.
All right. So what has happened?
Now,
order. Are you implicated in the order?
Yes. Now what has happened, my lord? After issues are framed. Now, no issues, maybe due to oversight.
First read the order. Let us see the order first. Then come to the issue.
Order is at Annexure A.
Page 44.
Page 44, precisely.
R2 being.
Before that, my lord, I must read what is against me.
No. Let us read this and then come back so that I'll understand what is against you.
Page number 44, jote, my lord.
Respondent 2 being the owner.
Yes. In order to, I'm reading page number 41, my lord.
No, 44 is the operative portion.
44.
Internal page 26.
Yes. Internal.
Adodi.
Respondent number 2 being the owner of auto rickshaw involved in accident is liable to pay. Now, how did the...
Read further.
Further, the respondent number 1, insurance company is directed to pay compensation amount to the petitioner within 1 month from the date of award, and he is at liberty to recover the same from the respondent number 2, owner of the offending vehicle. So, this is where I am implicated.
This is the final order.
This is the final order.
So, nothing against R3.
Illa. Now, how am I, owner is the, how, why? That my lord will find at page number 41 of the petition.
Yes.
Why this implication has been cast upon me.
Yes.
Page number 41, 4th line, my lord. In order to disprove the contention taken by the respondent company, the respondent number 2 and 3 have not stepped into witness box. And also they have not produced driving license, copy of driver. So, meticulous entire case, it shows that driver of auto was driving the auto without having valid license. Hence, the owner of the vehicle violated the policy terms and condition. Hence, the owner of auto is liable to pay compensation. Can get a para 18 in support, last line, ma'am. In support of his written statement contention, he has produced Xerox copy. Now this is pertaining to my client. Xerox copy of sale receipt, transfer of insurance and delivery note. Respondent number 2 did not step into the witness box and produce original RC record to show transfer of the RC in name of respondent number 3. There is no material before the tribunal to show that auto rickshaw is in name of the third respondent. The respondent insurance company produced copy of insurance policy. On perusal of the said document, the insurance is standing in the name of second respondent by name K.S. Vasvi Prasad. So, I'm of the opinion that respondent number 2, K.S. Vasvi Prasad, is liable. So, based on insurance policy, the learned judge has come to a finding that, okay, because you did not appear based on insurance policy, let me take it as that you are the owner. No problem. Now
you produced that copy of the sale receipt, transfer of insurance.
With objections, it was all filed.
Along with the objection.
Objection. Now, my lord, no issues were framed. Having said that I'm not owner, the learned judge.
Issues. Let us see the issues.
Issues, no, no. Issues, my lord, will find on page number 68. Annexure E. Annexure E, page number 68.
You come to page 24, issues are there.
My lord, I have produced that as a separate annexure.
Why we should go to that? Is that different from the judgment?
No.
Come to the judgment, page 24.
Yes.
Internal page 6.
Yes.
It will be the same. It will...
Certainly. Yes. Whether issue number 1, whether petitioner proves that so and so, whether petitioner is entitled, what order?
Is there anything else in the issue?
No, nothing else. No.
The petitioner proved that sustained injury at about 4 p.m. Somnal Bengaluru, riding motorcycle bearing due to the rash and auto rickshaw bearing so. All right. So whether you filed statement, R3 also filed?
R3 just filed wakalat and did not participate anything in the court proceeding. Apart from making a representation, did not even file objections.
All right. Then.
Because they knew who was the owner.
Who?
R3, who was the owner, knew. He just files wakalat and keeps quiet.
Then the onus is on whom more?
Now issues are not framed. Who is the owner? I whatever material I had.
No, R3, did he file statement?
No, ma'am.
All right. Now, according to the petitioner, both of you are the owners. If petitioner says, claimant says both of you are owners.
I filed.
And R3 does not come before the court and you are stuck. Is the onus not lie on you?
Certainly, my lord.
Now, once you have produced those documents along with your statement of objections, what prevented you from leading evidence and saying so and getting them marked?
Now what has happened? 2 things, my lord. I can be candid to in my submission. One is the issues, who is the owner was not framed. Maybe the counsel before the trial court ought to have pointed out to the judge saying that I'm not the owner, frame the issues on that point. Ought to have done. It was not done. Second, this all happened during the COVID period.
In the statement of objections, you stated anywhere that you are not the owner?
Yes. That is what I read, my lord.
That you are transferred and given.
Yes, para number 6 and 9, what I read to you. So, if my lord is right in pointing out what prevented me from saying in the trial court that I am not the owner and assisting the judge by saying that frame this issue. Then only.
All right, if the court has not framed issues, what were you doing?
That is where the lapse on my part is there, and I admit it. Having known that, my lord. Now, when this order was passed, this order, impugned order was passed, the review petition was filed. That see, these issues were not there, but this is what has to be corrected. Yes, I did not, but it can be considered. Now, in review petition, which is at, which my lord will find at annexure Q, page number 289, the operative portion is at page number 300, my lord. Review petition.
Review before which?
Same court.
The motor tribunal?
Yes, tribunal, ma'am.
You filed a review?
Yes, ma'am. Now, page number, annexure Q, page number 300, my lord.
Yes.
The last para I'll read. With due respect to Honorable Supreme Court of India and Honorable High Court of Karnataka, in view of the ratio laid down by the Honorable Supreme Court of India and Honorable High Court of Karnataka, this tribunal has no power to review his own judgment. Correctly, my lord. Now, though this was brought to the knowledge of the learned judge that this thing has happened, the judge was of the view that I don't have powers, so I'm before my lords. Now, interesting thing, everybody knew what is the true fact, but how is it suppressed? That I will show it to you, my lord. Now, after the issues is framed, my lord, the insurance company leads evidence. That, my lord, will find at Annexure J. Annexure J.
All right, you can reserve your argument. Let the other side come.
Oh, my lord, now I'll only say.
No, whatever your arguments now, the other side will have to rebut your arguments.
He's there. He's very much online, my lord.
I can see that, but he is not participating. So he should not say, I had just put it and I was in some other court.
That is a thing that he must take a risk of. He's quite a senior lawyer. My lord, my only submission.
Consideration.
If whole point I'm trying to make out is, as per section 2, with subclause 30, owner, Motor Vehicle Act defines owner. Now, I have produced a document.
Now you have produced those documents along with your statement of objections.
That was before the trial, before this honorable court, along with the IA for production of document, IA number 3, I have produced B extract. That 1 year before, if my lord can have a look
All
at
right,
my,
I agree with you. This will have to go back and you will have to adduce evidence there.
my lord, this can be set aside. This can be set
Let us see, or he has to come. What is the law on the point?
my lord, there can be only one owner. That's the point.
What is the judgment of the courts?
Now I will just.
Oh, this is not yours, is not the first case.
Yeah, certainly, my lord.
Several cases like this where people transfer the vehicles, but they don't execute this.
But this was done. In this case, this is a different case.
Your case, you have done it, but what does the court say? What is the law on the point?
Who is the owner is only liable. That's the law. Sir, can you please pass this, court officer? I will just briefly show one point. Page number 241, para number 47 and 48. Landmark judgments are there that my lords are already aware about.
Yes.
Para number 47. In Naveen Kumar versus Vijay Kumar, a 3-judge bench of this court held that in view of definition of the expression owner, section 230 of the Motor Vehicle Act 1988, it is the person in whose name the motor vehicle stand registered who, for the purpose of the said act, would be treated as owner. It is settled. This is
all right. You also have an insurance.
Insurance. Now, insurance does not determine, my lord, who is the owner. That is where I wanted to make it a point. Insurance company, in their evidence affidavit, they know who is the owner. I'll just take one second of my lord. Just have a look at the evidence of the insurance company, which my lord will find at Annexure J. I will just show my lord something very interesting. Page number 234, Annexure J. My lord, para number 2. I state that the owner of vehicle who being respondent number 2 has violated the terms and condition of the policy. I'll just stop there. So they have filed a evidence saying that I am the owner. Now turn the following page, my lord. Exhibits. Exhibit R3. Letter sent to insured with postal receipt. Letter sent to insured. And exhibit R5. Letter sent to owner and driver. Now, this is making it very clear. They themselves know who is the owner. Now, let's have a look. at page number 256, my lord, 256. 256 is a letter sent to my client. That is Exhibit R3. K.S. Vasvi Prasad, so and so. Dear sir and madam, we have received summons from the court in the above case in which you are respondent number dash blank. We have verified our records and find we have received no intimation about the said accident till date. That's all. So this is a letter, this is the exhibit marked by the insurance company saying that it is sent to the insured. That is me. And page number 259, exhibit R5, Mr. Anand Kumar, and so and so. Now, the subject, here they know who is the owner because that is their evidence shows.
All right.
So everyone knows the truth, but
Everybody knows the truth, but you don't want to substantiate the truth.
I will go all out to substantiate anything, my lord.
The onus is always on you.
Certainly.
You should have done that before the tribunal.
Certainly.
Which you have not done.
Certainly, my lord. And I'm before my lord's hands to speak truth.
Even if it is the insurance policies in your name, let's assume. The insurance company still should be liable to pay.
Insurance company should pay and will pay, but they cannot claim through me because the order says that subsequently you can claim from R2, which is me. I'm not the owner on the date. The RC is transferred. Yes, they can claim.
Driver doesn't have license.
My lord, that driver is not mine. That is R3.
No, whether that is established that the driver did not have a license.
I don't know who the driver is, my lord, because I had sold it 1 year back. I gotagilla who is the driver. So no liability can be fastened upon me. But I was not the lawyer before the trial court, my lord. I am before my lords. But whatever I can do to assist.
When I say new means not you, your client.
My brother colleague, yes. So, but having known the fact, it is my duty to assist this honorable court to lead the court in the right direction. My lord. If a short date can be given.
Correct. Learned counsel for the appellant is present. There is no representation on behalf of respondent.
My lord, I am the respondent.
He is there.
Elri, Mr. Hekade, ನೀವು silent spectator ನೀವು.
No, my lord. I was in another court, my lord, quota number 5, my lord. But I
That's
couldn't.
what I was telling your friend that your name
Yes,
was
my
shown.
lord.
You must be busy.
Because
arguing.
both were, my lord, that's why just that matter also they're coming. That's why just I was put
So
on.
your friend, because we did not have any other matter, I permitted him to argue a little bit to understand.
Sorry, my lord, I apologize, my lord.
No, it's okay. I will hear, he will address argument once again for your benefit.
Yes, my lord.
What he is contending is that he is not the owner, he has transferred it to R3.
Yes,
and he has produced certain documents.
Yes.
That is his only argument.
My lord, that see, my humble submission is, my lord, he is to, my lord, this intimate the RTO regarding the transfer of the vehicle. And if the vehicle stands in his name, my lord, then he will be considered as the registered owner, my lord.
We'll see. You can argue on the next date. I'll
Well,
give you.
any day,
When
my
is
lord.
it convenient for you?
Any day, my lord, I will come there and argue the matter, my lord. Because it is lower in the list, I will turn up.
25, 26?
My lord, some inconveniences there, 25th.
26, my lord, 2-3 matters.
Any day there after 28th. Yeah, the week following.
Any day, my lord.
First would be good, my lord. If
And
it is
even, my lord, my humble submission is, even, my lord, this the advocate appearing for the petitioner, he said that he will be, by mistake he has taken, he made a memo for dispensation. But actually, my lord, he wanted to take out notice to the owner also. That's why you will not kindly post it any day. So we will correct it.
Is it dispensed?
Another petition which is connected, my lord.
In the connected matter, my lord,
Connected matter.
Dispense.
Who's the claimant is also here, is it?
Yes, my lord. Mr. P. Suresh is appearing for the claimants.
Oh, he has dispensed notice to 2 and 3.
Yes, my lord. He said
that is in a different petition, my lord.
Maybe.
No.
Yeah, it's
Connected.
taken a risk.
No, no, it is arising out of the same accident. It's a claim, he is the person appearing for the
He's
petitioner.
also required.
Yes, my lord.
He's required.
Yes, my lord,
You-
his
you
presence
tell
is
him-
also required.
You tell that
Yes,
man
my lord.
appear before the court and he will
Yes,
have to
sir.
take out notice and
Yes.
you are not a party?
Me?
You're a party in a connected
My lord,
petition.
I am, and he has sought dispensation.
He must have thought only insurance will pay.
Yeah.
Yes, my lord.
And,
Now,
and
question
both
of
the matters are
liability,
clubbed.
that's why-
So there is a lot of ifs and buts and the,
My lord, even my lord, the Supreme Court judgment is also required because 3 or 4 judgments are there. If it's in the name of this present
I
appellant.
he has sold the vehicle, he has, other person has taken it enjoying for 1 year.
Yes, my lord.
And RC is also transferred.
All right.
That is before this court, my lord. And the law is also before this court.
Yeah, first,
First ಮಾಡ್ಕೊಡೋಣ.
first ಮಾಡ್ತೀರಾ, Mr. Hegde?
Yes.
Anytime, my lord, we are ready, my lord.
On the condition that you don't fool him on the first.
April 1st. He can fool me, but we can't fool you, my lord.
No, that cannot be. All right. All right, listed on
Much obliged.
first tape.
Obliged, my lord, obliged. Sorry for once again, my lord, sorry,
No,
my
it's
lord.
okay. In fact, I was telling your friend that Mr. Hegde must be busy on the other.
Certainly.
Yes, my lord. Quota number 5, my lord, that's the.
He is a busy lawyer, my lord.
No.
This court is aware who all are busy.
Yes.
What is your good name? Anand.
Amit Anand.
Amit Anand.
Yes, my lord.
You have been appearing on MF.
No, my lord. This is one-off case because of.
You are appearing in which cases mostly?
So I do appear for PBAP. I am their standing counsel. I do company matters. I do real estate, appear before tribunal, NCLT. This is the first time I've got an opportunity to appear before my lord.
Here you on first.
Certainly.
Obliged.
Much.